Indeed, it is in you we live, move, and have our being. Thank you for our dear nation, Ghana. We bless your name for how far you have brought us. We believe and trust that through all our changing scenes, you are with us and you reign in our midst. We thank you for the life of this great and noble university. We thank you for all various departments and aspects of our life as an institution. Thank you for the Faculty of Law, and we thank you for today's function, this great collaboration between the Law Faculty and the Ministry of Housing and Works. As we have met here for this colloquium, we invite your presence to be with us. Let your Spirit guide and direct all our discussions so that out of it, we'll be able to chart a course which will inure to our general benefit as a nation. Thank and bless you for all facilitators and commend them to you that use them to be a blessing for this program. Thank you for hearing our prayers, for we have asked for this and many more blessings through Christ Jesus our Lord. Amen. Thank you. Please let's sit.
General Yanasasini, a yabot in Zemayen, Moja nanum shieguye, de tohomayen, a drew menewoso, say a baby atwaso. Honorable Chairperson, Professor Mrs. Rita Akosia-Dickson, the Vice Chancellor of this prestigious university, the Dean of the Faculty of Law, Dr. Ernest Owusu-Dapaah, the Provost of the College of Humanities and Social Sciences, Honorable Justices of the Supreme Court, learned colleagues, Nananom, our invited guests, ladies and gentlemen. It is in this spirit of forging ahead together as a people to contribute our priceless quota to the development of and to drive our beloved country into the Ghana we want that has brought us all here together this morning from different walks of life to participate in today's colloquium organized by the Faculty of Law, KNUST, under the auspices of the Office of the Vice Chancellor, Professor Rita Akosia-Dickson, and in collaboration with the Ministry of Works and Housing, headed by the Honorable Minister, Honorable Francis Asenso-Boakye. Madam Chairperson, Professor Rita Akosia-Dickson, today's colloquium, organized by the Faculty of Law, KNUST, in collaboration with the Ministry of Works and Housing, is aptly in line with the mission statement that drives our noble and prestigious university, the Kwame Nkrumah University of Science and Technology, which, among other things, seeks to undertake relevant research and community engagement to improve the quality of lives of individuals. Madam Chairperson, the first of the two bills under consideration this morning is the draft bill on rent, which, among other things, seeks to consolidate the law on rent, to reform the existing enactments on rent, to remove the inherent constraint on housing supply, and offer incentives to stimulate private sector investment in the rental housing sector, and to maintain the protection of low-income and vulnerable tenants from abuse and arbitrary actions. The second bill under consideration in today's colloquium is the draft bill on the Ghana Housing Authority, which seeks to establish the Ghana Housing Authority to operationalize the government housing policy through strategies and programs, to organize public housing development, to exercise regulatory oversight over the activities of real estate developers, and to provide for other related matters. Today's colloquium, Madam Chairperson, on these two draft bills allows for stakeholders' engagement in assessing the rent bill and the Ghana Housing Authority bill. Without wasting much time, I would like to call on the Dean of the Faculty of Law, KNUST, Dr. Ernest Owusu-Dapaah, to give us his welcome address. Whilst he moves up stage, can we put our hands together for him?
Our highly respected special guest of honor, Honorable Francis Asenso-Boakye, Minister for Works and Housing and MP for Bantama constituency. Deputy Minister for Works and Housing, Professor Mrs. Rita Akosua-Dickson, Vice Chancellor of KNUST, Chief Director and Directors of Ministry of Works and Housing, my laws, temporal and spiritual, members of the legal fraternity, members of KNUST Governing Council present here, Provost of College of Humanities and Social Sciences, Professor Charles Kwakubafo, Provost of our colleges, Nananom, Media Fraternity, Directors, Deans, Heads of Departments, Senior Members, Junior Members, distinguished ladies and gentlemen. On behalf of Management and Faculty Board, I wish to heartily welcome you to KNUST Faculty of Law to be part of all these important consultative deliberations on two important bills currently being sponsored by the Ministry of Works and Housing, namely the Rent Bill 2022 and Ghana Housing Authority Bill 2022. Before Chairperson for this event is officially announced, permit me to say a few things about what has been going on as far as our Faculty of Law is concerned and how this event came about. Established in 2003 with 57 pioneer students and 12 academic staff, including myself, the faculty has grown its enrollment, and currently we have about 1,150 students from diverse backgrounds pursuing one of our three academic programs, namely Bachelor of Laws degree LLB, Master of Laws degree LLM, and Doctor of Philosophy in Law, PhD. Our faculty building was designed for student population of 500 in 2007. Indeed, it is a pleasant coincidence. It is a pleasant coincidence that our Faculty of Law, which is in desperate need of more classroom space, lecturers' offices, a moot court room, is a host to stakeholders from length and breadth of our country that are going to rigorously review and refine the Rent Bill and the Ghana Housing Authority Bill. We urgently need the second phase of our Faculty of Law constructed to create more room for a teeming number of students, lecturers, and moot court activities. And I'm happy that the Honorable Minister for Works and Housing, who is also MP for Bantama, is here. And I hope that the prayer I'm making is being made at the right time. We are looking for philanthropists and well-meaning benefactors to come to our aid. We are also building a network of friends of KNUST Faculty of Law to partner us in mobilizing resources and other collaboration. Please feel free to register with the DEX outside the auditorium or contact us anytime regarding how you can help, and we will acknowledge. And I'm happy to say that our Vice Chancellor is very generous, that if someone will even volunteer to put up a whole building, she has agreed that the building can be named after that person or that entity. So shall we clap for her? Consistent with the funding mission of our university, we are seeking to position the Faculty of Law as a leading international science and technology-oriented legal education provider in Africa and beyond. Central to this vision is our intention to enhance effective teaching and learning environment and excellent research, particularly interdisciplinary collaboration. The broad spectrum of experts from College of Art and Built Environment, School of Business, and stakeholders from the housing sector, carefully selected to partner our experts at KNUST Faculty of Law in today's colloquium is a monumental evidence of our unalloyed commitment to interdisciplinary collaboration. As a Faculty of Law, determined to contribute towards the vision of our Vice Chancellor, which is to position KNUST as a competitive global research-intensive institution for advancement in science and technology for industrial and social uptake towards sustainable and global development. We have aggressively embarked upon many initiatives, including today's event, Colloquium on Rent Bill 2022 and Ghana Housing Authority Bill 2022. Before the program is concluded with the formal vote of thanks, let me seize this earliest opportunity to express our gratitude to our Vice Chancellor, who accepted the decision of the Honorable Minister of Works and Housing, Honorable Francis Asensu-Boakye, to mandate KNUST Faculty of Law to host and conduct national colloquium on the two bills, the Rent Bill 2022 and Ghana Housing Authority Bill 2022. Thank you, Madam Vice Chancellor, for your leadership. Thank you, Honorable Minister, for your massive vote of confidence in our university and our Faculty of Law. As a Faculty of Law, determined to shape thinking of national and international community about the crucial nexus between law, science, and technology, we have eminent legal scholars and lawyers public lecture series, through which celebrated scholars like Professor Kofi Oten Kofor of University of East London, Professor Sir Jonathan Montgomery of UCL London, Professor Justice Samuel Kofi Dateba, former Supreme Court Justice of the Republic of Ghana, have delivered high-impact lectures on topical themes. Apart from the public lecture series, we also have KNUST Forum for Current Legal Issues, which provide platform for intellectual engagement on topical issues of the law. We have hosted Professor Oswald Kafu-Isineja on the Russia-Ukraine crisis, and recently also hosted Nana Dr. Susubribi Krobia Asante to mark the 30th anniversary of the referendum which approved the 1992 Constitution. The Faculty of Law is conscious of its duty towards community locally and nationally. We have embarked upon outreach program for hospitals known as on-site medical ethics workshops. The project seeks to minimize incidents of medical malpractice by reminding healthcare professionals of their ethical and legal duties towards patients. We've carried out 3 successful on-site medical ethics workshops at Kumasi and Sunyan Regional Hospital. Before concluding my welcoming remarks, I wish to share information on 2 major events ahead of us this year and next year as KNUST Faculty of Law. In the last week of August 2022, our faculty will be hosting 8th Median International Conference on Law, Science, and Technology under the theme, Harnessing Digitalization for Economic Development, Law at the Intersection of Science and Technology. The other good news is that KNUST Faculty of Law has been selected to be the host of the prestigious Christoph Hens All-African Human Rights Movement Competition in 2023. This competition is organized by University of Pretoria Center for Human Rights, and it will bring 120 universities from more than 45 countries into KNUST Kumasi next year summer. Undoubtedly, KNUST Faculty of Law is determined to play its part in the new focus of our university after attaining 70 years. We have resource constraints, but I'm confident that our Vice Chancellor and our Provost will continue to assist us to drive this aggressive agenda of improving teaching, learning, research, and service to community. It is absolutely heartwarming that our policymakers and politicians will give academics, the bench, the bar, practitioners, and industry players the opportunity to make inputs into these two important bills, the Rent Bill 2022 and Ghana Housing Authority Bill 2022, which will ultimately affect our entire Ghanaian society. On that note, I wish to encourage everyone present here and online actively to participate in the 3 sessions of panel discussion that will follow the opening ceremony. And I wish to say Akwaba to KNUST Faculty of Law. Thank you.
Thank you very much, Dr. Ernest Owusu-Dapaah, Dean of the Faculty of Law, for that wonderful welcome address. At this point, we would like to call on Professor Oswald K. Senieja to come and introduce to us the chairperson for this occasion. Let's put our hands together for Professor Oswald K. Senieja as he comes up.
Dignitaries, ladies and gentlemen, I'm doing the official introduction of the chairperson for today's event. On this special occasion, it gives me a great pleasure to introduce the chairperson for today's event, which is a national assignment. To be brief on the chairperson's credentials, which gives this occasion prominence. She is a full professor of pharmacognosy. She is the current vice chancellor of Kwame Nkrumah University of Science and Technology, Kumasi, as the first female vice chancellor in the history of the university. She is a pharmacist by profession, having obtained her Bachelor of Pharmacy and the Master of Pharmacy or Pharmacognosy degree from KNUST in 1994 and 1999, respectively. She holds the PhD from King's College London, University of London, under the sponsorship of the Commonwealth Scholarship Commission. She also holds a graduate certificate in academic practice from the University of London and holds a Commonwealth Jubilee Fellowship from UK. As a pharmacist, she has served on several statutory and non-statutory boards and commissions of KNUST and was also a member of the Governing Council of the Ghana Baptist University College, as well as a founding board member of Transforming Teaching, Education, and Learning, a Ghanaian registered non-profit organization. As an academic, her expertise has impacted the international scientific community through training, mentorship, and scientific appraisals. She has attended several conferences to present research papers and published over 80 scientific articles in peer-reviewed journals. In addition, she has authored or co-authored 5 books and book chapters within the domain of her expertise. Her exceptional contribution towards education have earned her several awards, including the Ghana Women of Excellence Award, the 2021 Outstanding Contribution to Tertiary Education in Ghana category, and GLEADS, Ghana Women of the Year Award 2020 for Excellence in Education category. She's devoted Christian and married with 4 children. Without further hesitation, I present to you our own prominent Vice Chancellor, our mother, and my own sister. Thank you very much. Thank you.
Thank you very much, Professor Seneja. Very generous introduction. In fact, over-generous. Okay. Honorable Minister of Works and Housing, Honorable Asenso Boachi, Deputy Minister of Works and Housing, Chief Director, and Directors of the Ministry of Works and Housing, Nananum, Justices of the Superior Courts of Ghana, Judges, Heads of Government Departments, Security Operatives, esteemed invited guests, and indeed, members of the university community, including my dear students. It is with great excitement that I welcome you to the Kwame Nkrumah University of Science and Technology, the best university in Ghana. Thank you. Thank you very much. This very important and timely colloquium on the Rent Bill 2022 and Housing Authority Bill 2022 is the culmination of an enormous collective effort by the Kwame Nkrumah University of Science and Technology Faculty of Law and the Ministry of Works and Housing. And Honorable Minister, we are really grateful. Thank you. Indeed, I should like to take this opportunity to further express our appreciation to the Honorable Minister of Works and Housing for choosing KNUST for this very important national assignment. Honorable, thank you once again. You couldn't have gone anywhere else but to come to the best university in Ghana. Thank you. I would particularly want to also thank the Faculty of Law team, ably led by the Dean, Dr. Ernest Owusu Dapa, for working around the clock within a brief period of time to ensure that this event takes place here today. I would also like to wholeheartedly thank you as selected panelists, able ones indeed, and all participants for honoring the invitation to deliberate on all aspects of the 2 bills, irrespective of the short notice. Your commitment is indeed very much appreciated. I think our panelists deserve a round of applause. As you all know, housing is an important component of the 2030 Agenda for Sustainable Development and an essential driver for achieving many of the Sustainable Development Goals. Adequate and affordable housing can create economic opportunities and lead to the development of several sectors of the economy, including education. The government has shown commitment to working with key stakeholders to implement a national housing policy with the intervening laws on the rent and the Housing Authority Bills 2022. In the current scheme of things, the increasing housing delivery deficit in Ghana is due to the high population growth rate, urbanization, and inadequate supply of housing units to meet the growing demand. To say that this is an event of national interest is indeed an understatement. Nobody is insulated from this problem, as currently the pressure on housing infrastructure is everywhere. Therefore, this event has come at the right time because it will open avenues for us to set out key priorities, develop concrete plan of action, and practical approach to delivering on key housing targets based on detailed international comparative analysis. This indeed is a national exercise. And what we do here today, distinguished ladies and gentlemen, would go a long way to affect generations to come. I would, therefore, entreat you, our dear panelists, who are all carefully selected among policymakers, academicians and experts, landlords, tenants, rent control officers, lawyers, judges, are experts in the building industry, traditional authorities, estate agents, builders, NGOs, local assemblies, and key interest groups to be measured, candid, objective, and accurate in your submissions. I have no doubt whatsoever that our able panelists are uniquely placed to give us a very stimulating and invigorating debate, discuss and highlight the key issues, trends, and needed reforms and reviews in the bills, giving your diverse background and expertise. I am very optimistic that in the end, we will present a balanced contribution to the bills and the consideration for the benefit of all of us. On that note, let me admonish you to kindly do yourself a favor by simply relaxing as you take it all in and contribute effectively to the conversation. We do very much appreciate your making time for this very important program, and we thank you very much for your time. Thank you all for coming. Thank you so much.
Thank you, Madam Chairperson, for that brief and succinct remark. At this point, we would like to introduce to us our special guest of honor for today's occasion. And he is in the person of Honorable Francis Asenso-Boakye, Whilst he comes here to give us his speech, we would want to give him a round of applause as he comes.
The Vice Chancellor, this is the tallest pulpit I've ever used. That's right. Madam Chairperson, Deputy Minister, Western Housing and MP for Bunduri, Provost, eminent judges, Nana Mampohima, thanks for coming. Distinguished professors and lecturers, members of staff, friends from the media, ladies and gentlemen, good morning to you all. I welcome this opportunity given me this morning as guests for this important colloquium being organized under the auspices of the Faculty of Law, Kwame Nkrumah University of Science and Technology, the best university in Ghana. And I am a proud alumnus. And in collaboration with the Ministry of Western Housing. You may recall, Madam Chairperson, that on the 17th of May, 2022, I paid a courtesy call on you to discuss possible ways my ministry and this great university could effectively collaborate towards building a robust built environment. Thankfully, this collaboration has begun to manifest in the review of the Rent Act, 1963, Act 220, and the bill for the establishment of the Ghana Housing Authority. On behalf of the Ministry of Western Housing, I wish to express my sincere appreciation to you, Madam Chairperson, and the Faculty of Law for organizing this event. The importance of housing to us as individuals cannot be overemphasized. To many, it is more than a roof over our heads and a place to live and rest. The places we live is the center of the most important relationships that evolves in our lives. It is the place where we raise our families, receive our friends and our neighbors. Thus, having a place to live is a basic human right, which allows us to live a happy and fulfilling life. Notwithstanding these attributes, the growing housing industry that is supposed to provide or supply housing, especially rental housing market, is saddled with lots of challenges, with the majority of our citizens having to pay 2 years rent advance before having access to basic necessity of life, or this basic necessity of life. For this reason, the provision of meaningful shelter for all Ghanaians is a major part of the developmental goals of this government. And measures that are taken to address problems associated with the housing sector, among others, requires a review of the existing Rent Act, 1963. The Rent Act, as amended, was passed by Parliament 59 years ago, and therefore its relevance has been outlived by the current population growth and several other attendant difficulties that have engulfed the housing sector over the years. It has therefore become necessary, Madam Chairperson, to reform the existing legislation, remove inherent constraints on housing supply, maintain the protection it offers low-income and vulnerable tenants from abuse and arbitrary actions, and offer incentives which will stimulate private sector investment in the area of rental housing. Furthermore, the new act is intended to safeguard the rights of vulnerable tenants who have been outpriced by the uncontrollable highs in the cost of rental accommodation in the country. Ladies and gentlemen, to address the short to medium-term failures, market failures in the rental segment of the housing market, the government is in the process of establishing a national rental assistance scheme. The establishment of this scheme, Madam Chairperson, is meant to address the short to medium-term market failures in the rental segment of the housing market. This will be done in partnership with the private sector to provide low-interest loans to eligible Ghanaians to enable them pay rent advance. This will be done. The ministry has therefore submitted a memorandum to Cabinet for consideration and will begin implementation after the needed approval has been obtained. Distinguished ladies and gentlemen, the growing housing market that is expected to supply homes for Ghanaians is also confronted with a lot of challenges that eventually make ownership very complex and also an expensive venture for most Ghanaians. The cause of these complexities are not far-fetched and can be attributed to the unpreparedness over the years to meet the challenges that urbanization and population growth present to us. Unfortunately, this is the situation in which we find ourselves as a country, as we are currently confronted with a rather huge housing deficit in excess of 1.8 million housing units, according to the 2021 Population and Housing Census. To address this precarious situation, there is the need for a concerted government policy direction that focuses on bridging the current institutional gap to provide mass subsidized housing for a large segment of our population. The government recognizes this huge challenge and has pledged to critically look at the general institutional architecture which drives the housing sector. To this end, the Ministry of Works and Housing has received policy approval for the establishment of a Ghana Housing Authority to regulate, plan, and manage housing development in Ghana. Currently, the Ghana Housing Authority Bill has been drafted, and we are soliciting for stakeholders' input to make sure that it's robust and achieves its intended purpose. I therefore call on all of you present here to critically review the bills and provide your valuable input before we send them to Cabinet and subsequently to Parliament for consideration and eventual approval. Before I take my seat, I would like to say a big thank you to Madam Chairperson and the KNUST fraternity once again for opening your doors and staying committed to this noble cause of helping to provide a sustainable and inclusive built environment that can stand the test of time. I wish you all a very fruitful deliberations, and I thank you for your attention.
Thank you very much, Honorable Minister and MP for the Bantama constituency, Honorable Francis Asenso-Boakye, for that wonderful address. Madam Chairperson, I would want to seize this opportunity to acknowledge some dignitaries we have here in our midst this morning. We have here in our midst the Deputy Minister for Works and Housing, Honorable Abdullahi Abanga, who is also the MP for the Bunduri constituency in the Upper East region. Let's put our hands together for him. We also have in our midst here the Supervising High Court Judge, Justice Kofi Akoria. Let's put our hands together for him. We also have here this morning the Chief Director from the Ministry of Works and Housing, Mr. Solomon Suwala. Let's put our hands together for him. We also have here this morning the Provost of the College of Humanities and Social Sciences, Professor Charles Marfo. Let's put our hands together for him. We also have here representatives from the Attorney General Department, Kumase. Let's put our hands together for Lawyer Cecilia Pepratechi. We also have here representatives from the fire service. Let's put our hands together for them. We also have here representatives from the Ghana Immigration Service. Let's put our hands together for them. At this point, I'll call on the Chief Moderator to come and introduce to us the other dignitaries and also constitute the first panel. Let's put our hands together for Dr. Ernest Owusu-Dapaah as he comes.
Chairperson, I'd first like to give a brief overview of structure of business for this colloquium. After the unveiling of the panelists, the first part of the day will have come to an end, and then we'll be left with the rare work, that is the critical dissection, reflection, and refinement of the Rent Bill 2022, Ghana Housing Authority Bill 2022. That will be done in 3 sessions. So we have the first panel, which will be discussing the general, constitutional, philosophical, other sociological considerations which should inform any attempt to legislate on landlord-tenant relationship, as well as attempt to legislate to facilitate access to affordable housing in the country. Now, to help us to do that discussion, we have the following panelists. We are supposed to be joined online by Professor Justice Sir Dennis Dominic J, Justice of the Court of Appeal for that panel, and also Professor John Tia Bugri, Provost, College of Arts and Built Environment. We also have on the panel Her Honor, Mrs. Gloria Mensah-Bonsu, Circuit Court Judge, Kumase. We have Mr. Kojo Bio Ejei, Lecturer, Faculty of Law. We also have Mr. Frank Abuade Danyasa, CEO of Danny Wise Estate, who is currently in Netherlands and will be participating in this panel discussion via Zoom. He's already with us online. So these will be the panelists for session 1 of the panel discussion. So as I said, they'll be reflecting on the philosophical, constitutional, policy context, and best practices in legislating on landlord-tenant relationship and also the housing sector. That will take us about 1 hour. And after that, we will allow 15 minutes for general discussion by members of the audience. As the Honorable Minister indicated, this is an opportunity for us to do a critical review and give the 2 bills the best refinements that they can before they go through the processes to become law. So this is an opportunity for us, representing the broad spectrum of the Ghanaian population, to make direct input into this important bill. Then we have panel 2. Panel 2 will be doing thematic discussion of the Rent Bill itself. So the Rent Bill 2022, panel 2 will be dissecting it. And to do that discussion, we have the following panelists. We have Mr. Hans Kojo Kodua, who is a lecturer at the Faculty of Law. Dr. Samuel Buodi Adakwa, a lecturer at Faculty of Law. His Honor, Mr. Fred Obitre, Circuit Court Judge and Additional Magistrate, and Rent Magistrate as well. And we also have another panelist online who is currently in Gambia. I'm referring to His Lordship Justice Alexander Osei-Tutu, Justice of the High Court, who is on secondment to the High Court of Republic of Gambia. He's also online. He'll be joining panel 2. And he's also an author on a very respected work on the emerging themes in land law in Ghana, recently launched. We also have a senior lecturer from the Department of Land Economy, Mr. Jonathan Zinzi Aite, to join the panel number 2. We are supposed to have had Barry Makode upon, Director of Legal Education in Ghana, Director of Ghana School of Law, who is also an author on a very good work on the land law in the country. But just yesterday evening, there was an emergency meeting notice on the platform of General Legal Council. And I should have even been there myself, but he, being a director of the Ghana School of Law, must necessarily be at that meeting. So he's unfortunately not able to join us. But he's promised to send his memo to us. So this will constitute the panel 2. Then we have panel panel number 3, which will be discussing the Ghana Housing Authority Bill, which is like a new creature. The Ghana Housing Authority is a new creature altogether. And to help us to do justice to that critical review, we have Professor Resford Asasi Opon, Department of Architecture. We also have Professor Divan Ahaji, Head of Center for Settlement Studies within Kabi. We also have the CEO of Go Street Real Estate Consult Limited in the person of Mr. Mark Kakraba Ampe. We also have Dr. Chris Adomako Kwache, Head, Department of Commercial Law, KNUST-TEK. We have a traditional ruler, Nana Ajakuma Difie II, Asante Mampong Hima. And we have a lecturer from Department of Accounting and Finance, KNUST School of Business, KNUST, Dr. Nicholas Ade Buama. So these will constitute the panel 3 to discuss the Ghana Housing Authority Bill. So these are our panelists. So we would like to introduce them before we start we reorganize, and then we start the very first panel discussion. So please, when you are called, you rise up for the audience to know you. Her Honor, Mrs. Gloria Mensah Bunsu. For Joe Bio Eje Esquire. Frank Abuaji Danyasa, he is online, but when we reorganize to be projected so that you see him, those who are online actually see him already from Netherlands. Professor Bugri too will be projected, and then you will see him. Mr. Hans Kojo Kodua. Dr. Samuel Bodia Dakwa. His Honor, Mr. Fred Obitre. His Lordship Justice for 6 to 2 is also online, so those online can see him, but he will be projected later on. Mr. Jonathan Zinzi Aite. And panel 3, Professor Resford Asasi Upon. Professor Divan Ahaji. Mr. Mark Kakraba Ampe. Nana Ajakuma Difie II. And Dr. Nicholas Adeboama. Yeah, so we would like to sorry, I think that I've made one significant omission. So the panel 3, we have Dr. Chris Adumako Kwachi. So with permission of the Prof. Chairperson, we'd like to reorganize the top so that we can have the very first panel discussion. Yes. So without wasting time, panel 1, please take up stage so that we start. We want to operate within time so that in a few hours, the chairs. Please, organizers, organize the top for the panel 1s.
Whilst we are reorganizing the stage to constitute the first panel, we would want to acknowledge the presence of the Ashanti Bar President in the person of lawyer Owusu Seche Esquire. Can we put our hands together for him? Hello. Please, we have about 5 minutes break to socialize. Students, there are a lot of dignitaries among us. This is a very perfect opportunity to walk up to someone you don't know. We have the minister here. We have a lot of dignitaries. Walk up to them. Let them share with you their experiences. They have a lot to tell you. So we have 5 minutes to socialize. But please, we are not entreated to move out. We are not entreated to move out. Just 5 minutes. Get up, relax, and talk to someone. 5 minutes to socialize. Thank you.
Can you alert Just bear with us. I'll get people to set up the projector screen so that we can see those online. Prof. Chair, Honorable Minister, dignitaries, ladies and gentlemen, we are behind time, so without waiting any longer, we have to start first panel discussion. So we've introduced the panelists already. For that matter, we are not going to belabor the point. As and when they are making contributions, I will mention their name again so that we don't waste time because we've done the introduction already. And we also have one panelist who is in the Netherlands, is online. We are getting our IT team to put the projector screen so that those of you who are here can follow, but he is online, so as and when he has to come in, we will pick him through the speaker. So please, when the panelist online has to make input, then you release him so that we will hear him over there. Now, if they're able to get the screen also, those of us who are here will be able to see him, the screen. Thank you very much. Yeah. So as the keynote speech by the Honorable Minister for Works and Housing indicated one major law reform in the area of housing, especially the relationship between landlord and tenant, is taking place now, and there is what we call the Rent Bill 2022, which is before us. We've circulated it long before today. We have our panelists and, of course, all of us here to think through various aspects of this Rent Bill 2022 and make the necessary suggestions to improve the principles, the institutional arrangements, and everything relating to this bill, so that eventually when it is passed into law, it will address all the problems that we are aware of as far as the existing Rent Act is concerned and the related legislation. So, to all of us as panelists, before I will address any panelists in particular, as far as the current Rent Act is concerned, it was passed in 1963, and we know it as Act 220. A lot of views have been expressed by commentators in the literature, some going to the extent of saying that, well, the political economic context or the model of political economy being practiced at the time that that legislation was enacted is entirely different from our current dispensation. And for that matter, the underlying philosophy, the underlying political culture is different, so it is not fit for purpose. And that is one of the major arguments for asking for reform of the Rent Act, 1963 Act 2020. Do you share some of these comments by commentators? Maybe Professor Haji of Center for Settlement Studies.
Okay, hello, thank you very much. Yeah, in terms of the ideology and political economy, I would say what happened in 1963 is as relevant today. In fact, when it comes to the issue of housing, since the post-war era, housing has been seen as a welfare issue. So it's not a question of because a government is socialist or capitalist. It's a welfare issue. But then within that category, we have three dominant styles. We have what we call the social democratic welfare. Then we have so for instance, countries in the Scandinavia, Sweden, practice the social democratic because they believe in equal distribution of income. Then you have the cooperative affair or cooperative welfare, which is practiced by countries like Germany, Italy, where government targets those who are really in need and try to help them. And they also try to encourage NGOs and welfares. So it's still a welfare system, but a bit different from the Scandinavian. Then we have what we call the liberal welfare scheme, where it is capitalist-oriented, but they still target the needy. So this is where the US and, for instance, the UK are also involved. The problem we have in Ghana is that we might say you are practicing the capitalist system or whatever, but are you really targeting the needy? So, because it's supposed to be a welfare issue targeting those who are most in need. And that is where I think Ghana as a country, we haven't clarified our position in terms of the welfare, whether we are social democratic, whether we are cooperatives, or we are liberal. But when you look at what is we are practicing, it tends to look like we are practicing what I would call elitist welfare. In the sense that even though we say we are burden for those who are in need, it doesn't get to them. So that is where our problem is when it comes to the welfare issue. So generally, housing is a welfare issue. It has nothing to do with socialism or capitalism, but those three streams. Thank you very much.
Ahaji, we would like to pick thoughts of our online panelists, Mr. Frank Abuade, Danyansa. So IT people, if you release him so that we can hear him. CEO for Danny Wise Estate and Construction, and the 2014-2017 Ghana Property Awards winner. If we can have your thoughts.
Hello?
Yes, please. Go ahead, Mr.
Yes, good afternoon to everyone, most especially the Honorable Minister for Works and Housing, Honorable Asenso Wache, and the Chairperson, the Vice Chancellor, Professor Mrs. Rita Dixon, and all protocols of the our guests who are there today. Thank you very much for having me. I think, yes, to start with, I believe that what Professor Haji mentioned, yes, it's still relevant today, but I would want to give a brief description of how we are fed as a country from the Nkrumah era to today as we speak. And then we will all have a clear picture whether we are practicing what is mostly to be practiced or we are just playing around the issue. Yes, so in 1962, former President Nkrumah had housing at heart. And from a 7-year development plan, he acknowledged the fact that housing was a major aspect of government policy and an important influence on productivity of labor. So his government at the time made sure that there was availability for housing, stimulating the flow of loans through 1, banks, 2, insurance companies, 3, building societies, 4, pension funds, and so on. The question is, do we still have these institutions in place? If yes, why are they not supporting government's agenda in terms of housing delivery? So that's a thought-provoking question, and I think everybody can keep asking those questions. In that event, it will be necessary for government to finance some part of the construction cost from its own resources. So then, at the time, he was thinking that government will try, in addition, to arrange the extreme, that is when the local means fail, foreign loans for housing purposes, which today, the reality has changed. Now, investors that we have dealt with are no more interested in giving out loans like the credit facility anymore. That is how we should be able to review when we want to approach investors for construction of these housing facilities. They are not interested in debt financing, they are mostly interested in equity financing. So a clear example is Saglemi Affordable Housing that was developed years ago, 5,000 housing units. We had a loan from the Brazilian government, $200 million. The houses are there, they've not been able to complete. So it means that we who went to borrow the money, we are now going to suffer generations to pay the debt. But if it was equity financing, where the investor owns half of the project, then the government also owns half of the project, everybody will ensure the project is successful so that they get their gains. Then secondly, to the Rawlings era, the housing sector saw sprawling housing estates at Adenta, Sakumono, Lashibi, and on the Sprinters Road in Accra, Smith estates all over the country were constructed under late former President Rawlings. So you have the Smith Flats in Kumasi in Esuyebua, which is still serving its purpose over the years. Just that, as usual, typical Ghanaian attitude, maintenance has been a problem. Forward, we go to former President Kufuor. To be precise, on November 28, 2006, our former president had a review of the national shelter policy, which was done by government as part of its drive to secure the needed partnership and resources for the supply of more affordable housing. At this period, Ghanaians were made to understand that government was putting out together land banks, that is, land specifically for construction in future, in reserve for future generation, which covered an area of about 50,000 acres, that is 20,250 hectares, to support commercial estate developers. We never heard of that story again till today. Present at I remember the West African high-level peer exchange on investment on affordable housing, which was held at La Palm Royal Beach, had the US Department of State and Housing and Development and the UN Habitat at that time, the World Bank and the International Finance Corporations present. And Ghana was selected alongside Indonesia, Sri Lanka, Tanzania, by the UN Habitat to implement the slum upgrading facility on pilot basis. That is where we have like Old Fadama in Accra, where you have like Abu Abu area in Kumasi. There were few ones selected in Takrady to be part of the slum improvement project, and they called it slum upgrading facility. The main objective was to mobilize domestic capital for slum improvement projects and activities by packaging the financial, technical, and political elements in a way that would attract commercial finance. Assignment in Accra and Kumasi and Takra, they had this, as I've earlier mentioned, and the project was priority intervention, which was going to improve lives of the urban poor in line with the Millennium Development Goal, as our able Professor Rita Dixon, Vice Chancellor, mentioned. And it has come to reality that, yes, of course, the target is the low income in society. If this was achieved, Old Fadama that got burnt about years ago will not have happened. For it again, on July 12, 2010, under the era of the late President Mills, he directed the Minister of Works and Housing at that time to restart work on the affordable housing projects that was left and abandoned after the former President Kufuor administration. And this would have helped boost current efforts being made by government towards the provision of housing units for workers in the country.
So, Mr.
At that time, we had promises from most of the ministers at the time, and you all witnessed that the Sokoreman for affordable housing in Kumasi quite of late had Senate moving in to make sure that it is completed and people were given the chance to take it up. And as Professor Adi said, the target is supposed to be the poor, but in reality, it is the middle income and the high incomes in society who have still gone for the affordable housing units and are renting them out. And I've suggested some time ago.
Yeah, so Mr. Danyasa, I think in principle, you think that the effort to legislate on housing is a welcoming initiative. I mean, that's what I gather from your submission. But the other aspects that you are trying to address, we'll be coming to that just in a moment. So just hold on for the time being. Now,
okay.
Yes, just before we move on to the next issue, Mr. Ampem would like to share a few thoughts on this ideological context of the existing law.
Yeah, thank you. I think the question was whether the trying to have a new Rent Act or bill is relevant. And I think that the issue is that, for me, in form and the function the proposed act is supposed to serve, there's no significant difference between that and the 1963 Act. Perhaps maybe a review process should have looked at which aspects of the 1963 Act are no longer relevant because of the times in which we find ourselves, our current situation and circumstances. Because for most of the things, they are just repetitive with some minor amendments. One would ask whether it won't be prudent for us to look at the key things that we need to change to make that law still applicable to our situation than to go through an entire process to enact a new law. Thank you.
Right. Thank you. But I think ultimately, the tension has to do with how to strike the appropriate balance between landlords and also tenants. And then the second panel will be looking into some of these practical issues, because there's this thinking that if you look at the existing law, it's like the lawmaker is just thinking about the tenant, forgetting that the landlord might have also taken monies from loans and other areas to put up the building. So these are some of the points of misunderstanding or some tension which is going on as far as the landlords and the tenant is concerned. How should the law strike the balance? But we will get there during the second panel discussion. Now, having said that, if you look at Article 106 of the 1992 Constitution, one of the requirements for introducing a law or a bill on the floor of Parliament is that you must have explanatory memorandum which try to provide justification, including defects in the existing law or why you want to make the new law. Now, if you look at the explanatory memorandum to the Rent Bill 2022, the memorandum cites a number of factors as being the justification for the reforms which are being proposed. And these factors include the current population growth, housing availability, maintenance and housing quality, trend and technological advancement in the rental market, rental rates, housing redistribution, eviction controls, foreclosures, obligation on the landlord and tenants. These are some of the primary reasons which have been stated in the explanatory memorandum. Now, I would like to find out from you whether you think that these factors which have been stated are actually factors that provide a strong case for us to change the existing Rent Act, that 1963 Act 220. Or you think that they are just being made up, they are not really borne out by what we know in our society since 1963 up to date. Professor Asasi-Opon.
Thank you very much, Dean Esquire and moderator. I think that the question is very relevant because when we had this very short notice to prepare, you did us the honor to supply all the necessary materials, that is the rent bill and then the housing authority bill. And going through it, the question I was asking myself was that, what really is the difference between the two bills, the rent bill and also the housing authority bill? Because one thing becomes the other. If you are able to get the housing authority bill, certainly the rent bill becomes an issue. Looking at the reasons for having this bill, we've looked at the ideological or whatever fundamental reasons that we are thinking about. But I think that this ideology should be homegrown. Homegrown in the sense that we have a very peculiar situation whereby when it comes to housing, about 80% of the houses that we build in this country are by private individuals. How they get their monies, nobody can really tell. And how they fix the rent as well, nobody can really tell. So I was thinking that before we come to this point, perhaps we need a national debate on housing. The way we did the consultative assembly to come out with our constitution, something like that is done. But my understanding is that this is done, and now we are here. But the issues that we have here are not different from what persisted before, and therefore I think we can move. Thank you.
Great. Thank you, Professor Sase Opon. Mr. Bill, you want to have a word? Very well. Okay, now, Your Lady, because you preside over the gender court, there's a particular issue we really want to get your thought on, especially when you have divorce cases and other family law related cases. Sometimes you have issue as to accommodation arrangement. You need to make orders for accommodation arrangement for a spouse or for the children. Now, from where you sit as a circuit court judge presiding over gender court, so many cases, are there any problem areas as far as the Rent Act, Act 220 is concerned, for which reason we may need to welcome the proposed Rent Bill 2022?
Thank you very much. Good afternoon, all protocol observed. In fact, I think that from browsing through the Act 220, that is the Rent Act of 1963, I could not see any correlation of the act with respect to my work. Because what I do is that, you see, I have the gender court and I do matrimonial issues, as you said, and at the end of the day, I have to, if there are properties, to share them. If it's a joint property, to share it among the parties. And also to make orders for accommodation when there is a need for that. Sorry. And so after making those orders, my work is done. The enforcement of those orders are the administrative work. And so I don't have any direct dealing with landlords. However, upon looking at it critically, I realized that if you look at the Article 25(5) of the Act 220, which is talking about the offenses, it was very clear, the law was very clear that if you have short tenancy, for instance, or a monthly tenancy, you cannot, as a landlord, take rent advance more than 1 month. And if it is, the tenancy is more than 6 months, you can only take up to 6 months advance. So that was it. But this law sitting there was not being enforced. And so, and we all know the reason why it cannot be enforced, or it's very difficult for it to be enforced. This is because we have a housing supply deficit of about 2 million. And as my other colleagues, panelists have said, the private sector, they go in for what? Profits. And so they dictate the pricing, the market pricing of what they want to do to get out from whatever venture, business venture they have. So if, for instance, I have a case before me and I have to give an interim measure or order for one of the parties to move out of the matrimonial home for purposes of security, i.e. domestic violence or threat of harm and all that, you know that this is pertinent. It's so important that it has to be done. And before I go on, let me give you a scenario of what I'm trying to say. For example, there's some cases before me. Anytime they came to court, one party will be telling me that they have had a fight and there's so much acrimony that the case has been reported to the police. And therefore, you see the need to take one of them out of the matrimonial home. And so, when you make that order, and the order is directed to people with low income, for instance, then the point is, how do they get the money to go and rent where because of the fact that the law is not being enforced, landlords are taking at least 2 years advance. So in this case, how will such a person be able to go and rent? So the end result will be that you have to stay in that unfavorable marital home. And what will be the consequences? What will be the consequences? There could be deaths or injury, as we all hear on television. So this is the problem. This is the problem. So I am thinking that in line with such situations, then we need to look at it critically. And therefore, my reading the bill, I realized that the clause 26, which is talking about the National Rental Assessment Scheme, for instance, the purpose is to grant loans for people to pay advance rent. So maybe we will have to exploit that so that we may not face this spousal, killings and all that. So that is my thought about it, looking at it critically. Thank you very much.
Right, all right, thank you. Thank you, Your Honor. Now, if we look at the international scene, we have a plethora of international instrument frameworks, which directly and indirectly underscore obligation of state to provide access to housing. If you look closely at Chapter 6 of 1992 Constitution of Ghana, which is supposed to be the directive principles of state policy, it is said that there is no explicit articulation of the obligation of the Republic to provide access to housing, unlike education and also health. What are your thoughts on that, Mr. Kojo Bio?
Thank you, Doc. On the face of the Constitution, there are no express words suggesting that some form of housing should be provided for by the state. However, in looking at a provision like Article 36, Clause 2E, there is recognition by the state that for the most secure democracy, is one that assures that the basic necessities of life are the fundamental duties of the state. And what are these basic necessities of life? Among them include shelter. So this is not merely anything ministerial, but then a duty for the state to undertake. Mind you, it's also a welfare institution. There's a social contract between those who govern and the governed. So the gamut of chapter 6 contains the duties on behalf of the state, and the gamut of chapter 5 also touches on the duties of citizens. Now, in looking at the Committee of Experts report on a draft proposal of the 1990 Constitution, there was a recognition by the committee when they were considering matters of economic, social, and cultural rights, that the right to housing should be looked at by the state. Secondly, the Constitutional Review Commission of 2012 expressly recommended that the right to housing should be made part of the Constitution. It should be a fundamental human right. So I would say that matters of housing is not merely a commodity, but same should be viewed as a right, particularly because in the work of the Constitutional Review Commission, they looked at about our top 40 countries. And in these countries, there were experts stated that the right to housing should be made part of the fundamental human rights. So, much as same is not expressly stated in the Constitution, impliedly, same is a welfare duty for the state to look at.
Mr. Bill, assuming the recommendations of the Constitutional Review Commission were actually adopted and the right to housing is explicitly made part of the compendium of rights, a question would be, who is the duty bearer? Oftentimes, if you have a constitutional right, then there must be a corresponding duty bearer. So whose obligation will it be to ensure that citizens get access to housing?
There is that presumption that the government should have handled all these matters. But for that deficit, same the reason we have private persons engaged in this particular endeavor. Had the state been able to provide accommodation for almost everyone, this thing would have been cured. But then because of that deficit, same is the reason we have private citizens of a sort either cheating or trying to outsmart the poor. So that duty clearly is on the state, but because of that deficit.
All right. Maybe if we have the states having obligation to ensure access to health care, we have the state having obligation to ensure access to education. And now, thankfully, we even have the free universal basic education and the free SHS. To agree that it follows naturally that what would be the point if a person cannot afford shelter and he or she is homeless, and you say that you provided health care and then education to the point. And for that matter, you think that there's a natural obligation on the part of the state to also facilitate access to housing. I don't know what your thoughts are, but I can see, Mr. Ampem, you would like to say something. Good.
Thank you. I think that we need to put the whole issue in perspective. Now, the state has an obligation to ensure that its citizens are housed and they have access to decent housing. But housing is a very expensive venture. And we are building societies where we want people to self-actualize. And so we need to look at where there are gaps. In every society, you definitely will have the poor and people who, for no fault of theirs or whatever, fall below a certain income bracket and therefore cannot by themselves adequately access decent accommodation. And so we need to distinguish between the segment of our society that have the capacity to on their own have their own accommodation, and even beyond that, provide rental accommodation. And then the state now take responsibility for those who have no capacity. So I'm looking at our restructuring of the housing sector to look at how do we encourage those who have capacity to have their own accommodation. What kind of facilitation would government give them? So that, for example, housing cost is low, which will also translate in low rental on the market. And then for those who cannot afford, we look at social housing. And so, for example, I'm looking at the National Housing Authority to be focusing more on social housing. And the segments that belongs to that will be catering for are the low-income group. Whilst we also look at how do we make housing costs less expensive so that individuals who have the ability to build and rent will be able to do so at minimum cost and so therefore charge minimal rent. That way, then the Rent Act also kicks in. Because if you have a demand far below supply, far ahead of supply, because so much demand, there is little supply, the market forces will determine price. And so then the states having the responsibility to ensure that everybody has adequate housing may then look at how do we provide rent subsidies to those who cannot afford. Because the market forces will always determine rent. And if we want to suppress it, what you do is that, just as happened in the Rawlings era with the Rent Control Act, landlords were reluctant to rent out their premises simply because they cannot get the rent that is commensurate of the investment that they have made. And so we need to look at this in that context. Where do we strengthen those who have capacity to build and support them to be able to build, whilst we take care of those who cannot by themselves access accommodation? Thank you.
Right, thank you. Now, Mr. Abuaje Danyansa, I don't know what your thoughts are on this issue, if you want to have a bite.
Yes, Lord, thank you very much. I think that is the more reason why we had the definition for affordable housing in the Ghana National Housing Policy in 2015. And all of us, including Rita and AESL, we came to a conclusion that when an individual, like Ghanaian, spends less than 30% of his annual income, which includes utilities and other bills, on rent or on a house, then that person is within the affordable limit. So now, with all what my colleagues have said, how many people can we identify that they are able to spend less than 30% of their annual income on housing and are therefore supposed to be given affordable houses, as Doc just said? We have a difficulty, we have a challenge. So now the duty is on government, and that is where this argument has to be. Governments have to provide affordable housing for Ghanaians. In every district, it should be a deliberate approach, just like free SHS, just like health insurance. If we don't know, the basic thing is that even with hospital theory of needs, after food, which in modern day you can say are great, there is shelter, which in modern day is works and housing, before clothing. So if you don't have a place to live, how can you say you are going to attain health care? How can you say you are going to educate yourself? And let's all agree that just the recently ended population census, 10 million Ghanaians out of 30 million are sleeping under sheds, kiosks, bridges, wooden structures from the national housing census. So it means that it has to be an approach where every government that comes has to make it a point to put up affordable houses for the benefit of Ghanaians, including workers in the civil service. And to me, that is where we are failed as a country, because we in the private sector are making gains out of the problems or increase the rent because government does not have the power to moderate how we should control, because we don't even know where we got the money from. So if government wants to come in, then the number of houses provided by government will bring in competition. And when government is providing social housing, we, the private sector, will have our hands tied at our back because there will be more demand and then there will be more supply to equalize the demand. And that is where the problem is now.
Right. Thank you very much. Yes, Professor Hayaji wanted to add a few thoughts on that before you move on.
Okay, so yeah, thank you very much. So I think also Ghana, we need to position ourselves why we chose to become the first black country to become independent. Yes, it was because we wanted to be a leader on the continent. So it's either you are a leader or you are a follower. Now, why is it that Egypt, for instance, has a right to housing in their constitution? Why is South Africa having it in their constitution? Why is Angola having it in their constitution? Why is Ethiopia having it in their constitution? Why is Malaysia and all the progressive countries which believe in the welfare state have it in their constitution? So the country that wants to be a leader in Africa, what is preventing Ghana from having the right to constitution, housing in the constitution? So I think the issue that has been raised here in relation to revision of the constitution is something we have to look at so that this thing is critically taken up, as it was suggested. And I was just reading the work of Graham Tepo, who did a lot of work on, interestingly, Mr. Minister, it looks like the rent issue started even before 1963, and it was due to inflation rising, just like we are experiencing now. So one would say maybe this is the right time, and this is what the committee said after all the discussion. And I will quote here. It was clear to the committee that rent control alone could do no good without an increase in the supply of housing. That is the basic issue. And that is why, what is the government role going to be? And I can give you some data here to make us understand that Ghana has not done well when it comes to looking at housing. For instance, 3 years, 2015 to 2018, South Africa built 580,000. That's 3 years. That's a country which is committed to addressing the housing issue. And we spent 20 years on 5,000 affordable housing. You know, they are here. Angola, 2011 to 2016, built 70,000. Ethiopia, 2005 to 2011, built 140,000. Malaysia, in their 2020 vision, built 800,000. Can we point any data in Ghana, one single data, to say that Ghana built 40,000 houses in a year or within a period? It's nowhere to be found.
But Professor Ahiaje, I mean, those observations are well noted, but I think that are we not being too hard on ourselves as a country? Especially.
No, that's why I made reference to the first black African country to gain independence. You started from a point.
Yes, I want us to come in and say that those countries that we have cited, there's no comparable data necessarily that they have, let's say, that a full-blown, probably like a free SHS, where all those who have reached the secondary school education, they don't pay school fees. And then the national health insurance, and then free universal basic education. So, and we also look at the resources availability. And that is why some commentators in the literature will argue for what we call the gradualism or the incremental approach as far as direct provision of housing by the state is concerned. It's part of the ideas expressed by some commentators in the literature.
Maybe just one point to let me see. Let's take it over the years. We have always been told that the country was growing. And there are situations where Ghana is touted as the top in West Africa. So the question I ask myself is, at the time that you are growing and you're on the top, if you cannot deliver the houses for your people, then when are you going to deliver them? See, that's the argument. Then it means that maybe the data we are being given is not correct. Because if you are really growing as we are saying, and the indicators are correct, it's something that you should be able to provide certain facilities for your people. At that time, you are not able to do it. Is it at the time of inflation now that we are going to do it? You see, those are the dynamics that I used to analyze it in that perspective.
Right, thank you. And then let me follow this up with this issue so that Professor Asasuopon can express some thoughts, and probably if Mr. Bia wants to have a bite of the cherry again. We know that as a country, we have made some modest efforts as far as state-funded health insurance scheme is concerned, and also free education at basic and secondary level. And these state interventions are consistent with prescriptions of directive principles of state policy in Chapter 6. Now, I would like to find out first from Professor Asasuopon, will you advocate that the welfare approach in healthcare and also education, which you have witnessed so far, be channeled towards housing sector and accommodation programs in the country?
Thank you very much, Mr. Moderator. When I made a point about we growing a kind of a home-based ideology, I don't know how it really went, because all these housing ideologies, especially the one that we are practicing for Ghana, with rent and all that, came from the what we used to call the least developed countries, the LDCs. But the issue is that I am not a lawyer, but I sleep with the Constitution of Ghana. And then when this issue came, I tried to go through the Constitution to see whether there is a whole chapter on housing. Because housing is a social good, whether we like it or not. And if you look at the basic tenets of life is what? Food, shelter, and clothing. What does that mean? That means that housing is a fundamental right as it's been expressed. But if you look at the Chapter 6, it does not explicitly mention the word housing. But if you do interpretation and extrapolations, you realize that it's talking about providing shelter so that people can have better livelihood. How do I enjoy life if I don't have a place to sleep? How do I make life if I close from work and I have nowhere to go? But there is a structural problem here, which is linked to our culture or customary growth as people. We have this mentality when we're growing at Kuntunhaya, Nechia Neko. And if you go back to your village now, you have a home. You have a place to sleep. But the houses are empty. It is when you come to the urban areas where this problem really exists. So as people, we have not really conceptualized housing as part of our well-being and say it's a social welfare. We have it. But the bottom line is, how do we really make it real? That is why I was saying that it is not too late for us to really engage, as we are doing, to make sure that we see housing as part of the fundamental human right, and it is enshrined with a whole chapter in our Constitution. Thank you very much.
Right, thank you. And on that note, Mr. Frank Abuaje Nyansa, I'd like to come to you. Ghana is now over 30 million as far as our population is concerned. So the population can only keep growing as we make laws to regulate our housing sector. will you advocate that housing development should be vertical rather than horizontal? That is to say that any legislative intervention in housing should direct that we build towards the sky rather than building horizontal, for fear that our land mass may get exhausted as the population increase. Mr. Abuadinyan, what are your thoughts on that?
Thank you very much. I think that one is about culture, and as you rightly mentioned, growing up, we all have been used to the fact that our parents want to build on their own, buy their land, get their own portion, and people fear high-rise buildings in Africa, not just in Ghana, in Africa. So how do we move away from that? It's education. That is why deliberating on these things has become relevant. How do we get people to be attracted to these housing units? Trust me, like I mentioned, Smith Flat is high-rise structure. How many years have they been there? About 20, 30 years? Are people not living in them? People are living in them. Have they died by living on the top floor? No. So why are we running away from the situation? So we need to make sure that these things spring up or happen on regular basis. And so the approach should be, and it's a proposal to government, because they can do it. We try our best, but like you rightly mentioned, most developers are looking for returns on their investment. So then, instead of going to put it as a district or a village somewhere, the person sees that he wants to go to Accra, he wants to be in the city centers where people can see those structures and purchase apartments, which is happening. In Accra, people are buying them. In Kumasi, almost about 6 floors, people are purchasing. But in the outside world, you live up to almost about 16th floor, 20th floor. And you are okay. The elevators are working 24/7. If we inculcate these designs and make sure that every district starts putting up these houses by government, because individual private sector cannot do this. Housing units in every district in Ghana will give us almost about 260,000 units of housing. And when we do this over a period of 10 to 15 to 20 years, we will bridge the housing deficit gap, of which leadership mentioned, from the 2 million units to almost zero. So I feel that education must go. Our generation should start seeing them. The more we see springing up of high-rise buildings, we will get used to them. And then the landlord can also be providing land, making lands available in every district, about 40 acres, for these 1,000 units. And whilst we do that, I think we can get there in the future.
Right, thank you very much. And I think because I've touched on whether there's a need for the law to direct developers to do more of the high-rise building, once you have a professor of architecture here, this issue cannot go without he having a say. So, Professor Sassi, upon.
Thank you very much, Dean Esquire. When it comes to social housing, it's a very big phenomenon. And then when you bring in high-rise buildings, and for a country like Ghana, then we are going on a certain trajectory. The so-called, I don't like calling them developed because we are also developed. So I say the so-called developed countries. They have had serious issues with high-rise when it comes to housing. In fact, we had a master of architect who championed a high-rise building, Le Corbusier, where in France he built a unité de habitation housing, and it led to a lot of social vices. Okay, where you bring a lot of people together, it has its own ramifications. Apart from that, when you come here, our main issue is about making sure that the services within these high-rise buildings work. When you talk of high-rise, if you build up to 4 levels, that is not high-rise. If you build up to 5 floors, that is not high-rise. High-rise buildings is where you go up to 20, 50 floors, some 100 if you go to Malaysia and Singapore. But how do you get the aged, for example, who needs housing, to move from the ground floor to the top floor without a lift? And if there's a lift, you have 24 hours electricity failure. You get stuck in the lift. How do you get there? So it's a whole gamut of issues that we really need to address. So because of our inability to provide the requisite infrastructure, that is why I am happy. We will come to that point, in the third panel, where we are thinking about provision of infrastructure, site and services and all that. If we are able to provide these services 24 hours, then we can think of going high-rise. If we don't do that, then you have more people dying in the lift, more than COVID. So it is important for us to identify that we are in a technological age and we need to move with them. People are building swimming pools on 50 floors and 100 floors. Are we not able to do that? If you are going to do that, how do we do it? The only way you can really enjoy life is living in a good house. I tell my students that the beauty of a house is not the outside, it is rather the inside. But you can only have this if the services are working. Thank you very much.
Thank you, Professor Asasopon. Mr. Kwajo Ajebio, just the last issue before I go to her leadership, and then we'll be wrapping up this panel and take contribution from members of the audience. Now, if you look at the Constitution, Article 1 says again, every proposed law, that is a bill, must uphold the fundamental human rights and, of course, the other provision of the Constitution. Having looked at the bill, will you agree that the two bills, they do not offend any provision of the Constitution? And related to that, will you say that the Rent Bill and then the Ghana Housing Authority Bill are consistent with principles which are enunciated in the case law and our jurisprudence?
To a larger extent, I would say yes, because there are a number of provisions in the two bills attempting to provide rights for both, particularly the Rent Act, attempting to provide rights for both the landlord and the tenant, and also even going further to prescribe against any forceful evictions. There are also appeal processes within the laws to allow for when it be if one is, if one is advantaged in any way, there are appeal processes available. So, particularly if you are aggrieved by the decision of a rent officer, you are allowed to even further appeal, right? So these are constitutional guarantees and safeguards within the Constitution. So clearly, most of the provisions within both the rent bill and also the Ghana housing bill, there's an attempt to in a way, uphold the tenets of fundamental human rights.
Right. Thank you, Mr. Bill. Your Honor, Mrs. Gloria Mensah-Bonsu, are there any final thoughts you will share with lawmakers in seeking to pass the rent bill and also the Ghana Housing Authority bill?
Thank you very much. As I was reading through the Rent Act of 1963, I realized that the law gives powers to the rent officers and the rent magistrates to admit relevant evidence that are per se not admissible. And I realize that if you look at the clause 6(1) and clause 10, 1A of this new bill has been repeated. But I was thinking aloud and I realized that the current position of the law on admissibility of private conversation is that it's not admissible. If you look at the case of Raphael Kubaji and so on, and Article 18(2) of the 1992 Constitution. So my thinking is, has the framers looked at this thing so that if in 1963, that's about 59 years ago, that was not the position of the law, and now this is the position of the law, would they continue to allow this law to be existent? Because what is going to happen is that, and mostly what happens, because I've been a district magistrate before, a tenant will go to the rent officer with a recorded, cassette or something between that tenant and the landlord. And the law says that it is admissible. So after they've prepared everything, and there is a case where they are not able to resolve the issue at that level, it will be sent to the rent magistrate at the district court. And the law says that he can also admit it. But here is a case that the current position is that it is inadmissible. So why are we repeating it? So I think that maybe they could look at that area critically and see what can be done. Thank you very much.
Right, thank you, my lady. So we have to update the draft so that it will reflect the ratio of Raphael Kubaji, that where you are recording a conversation and you've made it known to the other person, then subsequently, if the recording needs to be tendered in evidence, it will spring no surprise to that person, and that can be actually be used. Yes, Mr. Bio, you want to say something?
Yes, as part of my last bite. Last night I was looking at some rent agreements of Uganda. So in the preparation of rent agreements, you are required to also, as a necessity, produce your national ID. So you'll attach into as a document. Now, there's a provision within this rent bill prescribing against admissibility of terrorists, supposed terrorists. So in order to cure, in a way, this mischief, I think if we can, in a way, also as part of the preparation of rent agreement of a sort, also include some of these identification models.
Right. Thank you. I think that the panel 2 will be looking at the specifics. But just before we exhaust this panel, we'd like to find out comparative lessons based upon what you are aware of from other jurisdictions as to what we are seeking to achieve per our Rent Bill 2022 is in line with maybe best practices in jurisdictions which are similarly situated as our own. So, Professor, as your point.
Thank you, Dean Esquire. In fact, as a matter of being inquisitive, I wanted to know at least what happens in other jurisdictions. So I contacted a friend in the US. I don't know whether US is the same as Ghana, but at least a house is a house, no matter where it's situated, and rent is also rent. But interestingly, reading through what we have, this lady friend was kind enough, and just last night sent me about 8-point WhatsApp message. And I just want to read 2 of the points to see that it's consistent with at least what we have. Point 6, he says that as long as the tenant is in right standing with rent payment, he's considered as having rights to use of the house just as the landlord. No unnecessary restrictions can be imposed unless these restrictions were not laid out in the rental agreement in the beginning. When you come to 4, for example, it says maintenance of the house is a responsibility of the landlord unless the damage is clearly due to the negligence of the tenant, in which case the tenant will be required by law to fix the damages. The point I want to emphasize is that there are best practices everywhere, and what this bill seeks to do actually, matches up to what happens elsewhere. But the issue is, as Her Honor said, the enforcement. But the enforcement has to really look at our social structural fabric. Time will not allow me to give an anecdote. Interestingly, most of us sitting here are more or less landlords. And let's look at a situation whereby you have given your land. Yes, exactly. You have given your building to a tenant. You have agreed. He says, oh, I'll take it 2 years. He pays you, he stays in it for the first 2 years, and then it elapses, and he comes back to tell you that, oh, I'm going to renew it. But instead of paying 2 years advance, can you let me pay 1 year? What will you do? Thank you very much.
Right, thank you. So we come back to participants. The next 10 minutes, if you want to contribute towards the discussion or raise issue. Yes, Dr. Stephen Kofi Sondem. Somebody should have one mic. The MC knows. I think the MC should help with them.
I have a number of comments. First of all, I will draw the moderator's attention that the panelists restrict their contributions to the areas that have been defined for them. Some of the issues that we raise here are not supposed to be. We are talking about discussion of philosophy, policy, and the constitutional context of the bill. Yes. But if you look at some of the issues, I think they are not meant for this panel. Let me congratulate the Honorable Minister for taking the initiative to actually bring this discussion on board. From the discussion thus far, it is true that the issue is relevant to development in our society. I would like to comment on the policy and the constitutional context of the bill. First, the constitutional context. I have realized that a lot of discussion were devoted to the constitutional context of the right to shelter. The right to shelter is a fundamental human right. And Ghana has ratified, signed a number of international human rights instruments that contain the right to life, to shelter. If you go to South Africa, for example, squatters have been able to go to court against the government and compel the government to give them shelter. So there is no question about whether the right to shelter is contained in our constitution or not. Indeed, Article 33, Clause 5 specifically states that those rights that have been specifically mentioned are not exhaustive. Other fundamental human rights that will what? Promote democracy are deemed to be part of the Constitution. So the constitutional basis, we can't argue much about that. Now, if you look at, it's not only the right to housing, It's not only housing policies that have faced problems across developing countries. All pro-poor policies, social intervention policies throughout Africa have failed. They have all failed. And that is because of what we call side law. The target groups, the policy is intended to benefit a particular group of persons. Unfortunately, they end up not being the beneficiaries. And these are some of the things that we have to interrogate. If you go back a few years ago, state housing, it was meant for what? Those in the poor working, those who were workers who didn't receive up to a certain amount of, their salaries were low. When, in 1981, when Rawlings came to power and they set up committees to go to probe to those who were allocated these facilities, you realize that they were not a target. And some had even 5 houses. Some individual had 5 houses. In developing countries, these challenges are there. So I will want us to, if we are, my next point is, I don't know what the role of State Housing Corporation, the role of State Housing Corporation, which was established. I don't know whether it still exists or not. Okay. So if it was established and there was a reason, and I believe that reason was intended to facilitate poor people to get housing, what happened to that policy, or what happened to that institution, and it collapsed? Now, under the new bill, we are talking about an authority. Is it just a change of name? Is it a change of name, or it is something different from the role the State Housing Corporation was playing? We had Bank for Housing and Construction. I believe the policy rationale was to aid people within a certain, salary bracket to be able to acquire housing. What happened to Bank for Housing and Construction? I don't think it's still existing. So I would rather prefer a situation where the government can facilitate the acquisition of land by poor people who may be able to put up houses for themselves, rather than, because the state housing or the affordable houses, normally when they are completed, if you are not income earning, nobody will give it to you. And majority of the people who get them are probably those in the formal sector, unless maybe they want to make outright sale. And the outright sale is only the rich who can afford it. And if you are going to pay through the mortgage system, you must be earning. You must have some regular income. So, the Honorable Minister, thank you. The sagacity in you in promoting this discussion is welcome. And we will back you, we will support you to have a change in our social life. Thank you very much.
Thank you, Dr. Stephen Kofi Sondem. Yes, any participant who would like to contribute towards the discussion or raise issue before? Yes. Mr. Benjamin Afrani.
Thank you very much, Prof. Dean. The question that you asked as a moderator for the beginning of this program was about the underlying philosophy to the Rent Act. I would like to start by saying this is an observation that I've made, and I want to take the opportunity to also make this as a contribution to the proposed bill. There's a Latin simple philosophy or adage which says that nemo dat quod non habet. You cannot give what you don't have. The laws are made
by the state, but the houses are not owned by the state. This is a simple philosophy. So because of this, that is why Her Lordship is saying that the laws are not more or less administratable. Like after giving orders, you can't execute it because the houses don't belong to the state. So they should, the recommendation that I'm making is this. There should be a special scheme by the state, just as somebody suggested, that in as much as the state prioritizes health, education, we should also prioritize housing and think about how we'd be able to create a scheme which can even bring the private sector into it, because they are the owners of the houses. To go into what Mr. Abwaji said concerning Ghanaians are afraid of high-rise buildings, I disagree with him to the extent that we have lived in high-rise buildings which were even made of wood during the colonial period. We live in high-rise buildings in this school. All the halls are high-rise. Nobody is afraid of it. They don't even use the lift. As a land economist, we believe in a philosophy called the highest and best use of the land. Land values are mostly revolves around location. So we don't have to talk about high rise as if Ghanaians are afraid of. No, in fact, we even have prestige to live in high rise buildings. We have prestige. Ashantis, not being tribal, are particular about building high rise. Because we want to maybe show prestige. Where we call cities, we build high rise. But naturally, Ashantis are communal people. They are, you call it extended family systems. We have a particular architecture of building among the Ashantis. Wherever you go, you see it. It's with a courtyard in the middle. We have it. Nobody designs it. Once you have money and you want to build this in your head already. So and the rich will build it for their families, yet they will build high-rise building for themselves. That's the prestige part I was talking about. The point I also want to make about the availability of housing. Mostly, it's rather unfortunate the minister is not around, but I know when they gave us the opportunity to meet to socialize, I went to him and he's giving me an appointment. I pray that he will give me the opportunity to meet him, as he assured me. I will finish in a minute, sir. The availability of housing is not the problem that we have as a country. There are so many uncompleted buildings sitting in the bush. Please, we have to get a scheme which would be able to help us finish these buildings in the bushes. They are owned by private people. I think if there is a scheme which would be able to finance it, would be able to get people living in good houses. Thank you.
Right, thank you, Mr. Afrane. We take our last two contribution, and then we will end this particular session of panel 1. We go for brief snack break, and then we come and have panel 2 and panel 3.
Thank you very much. I have really enjoyed every bit of the discussion. My concern has got to...
Please, your name and your designation.
Well, my name is Pastor Alexander Japon, formerly Department of Land Economy, but currently I'm at the University of Cape Coast as a student. My concern has got to do with the type of housing that we actually construct. I remember 20 years ago when I was studying under Professor Bugri and then Professor Zinzin, they took us to a building on this campus where the substructure is composed of atakwame, but the superstructure is made up of actual brick, what do you call it? The bent brick, yeah. My issue is this. We are talking of affordability of housing, the need for us to have housing stock and all that. And we also know that cost of construction is always very, very high. Cost of material and so forth. Now, this can also be, say, a direct question to our astute professors. What is happening to that particular technology? Because you intimated that there is a need for us to have that homegrown philosophy. What has happened to that technology where we can use, leverage the atakwame, which is available in our construction? And that, to me, will go a long way in making our housing very affordable. The final point is the type of structure we live in now. My professors taught us what they call structural obsolescence. There are some structures, there are some rooms in our houses that are void, that are not being used. I live in my own house. It's a 6-bedroom house. I have only one wife, three children. And I ask myself, why did I do this? Putting up 6-bedroom house. And I don't want to also give out for rent because I don't want any trouble. And so in our design, how do we also look at this critically so that we will design houses that will not be structurally obsolete? Thank you very much.
Right, thank you very much. Yeah, so this, let's take the last contributor and we draw the curtain down on the first panel discussion. We go for a brief snack and then we come back to do the rare work. Because what we are doing so far, these are just generalized discussion, but the specific dissection and interrogation will be panel 2 and panel 3, in which we engage specific clauses of the bill itself. Yes.
Okay, thank you very much for the opportunity. Also, I also think that the initiation of the bill is a welcoming idea.
Your name and your designation?
I'm Martin Wana, and I'm a student of the Faculty of Law. So, realizing that the right to property is a fundamental human right, and so landlords who build or construct buildings, they have the right to decide who to give it out to and who not to give it out to. And also, the right to housing is also a fundamental human right. So there's the need to strike a balance, and in here, the state is the one that has to take the obligation. I mean, we have about over 20% of the lands being owned by the state, which are being encroached by people here and there. These lands could be used to, build affordable housing for people who are in need. And the problem we have also is that when these houses are being built or are constructed, the intended persons do not even get to benefit. Before they are completed, they are already shared among persons who are within the arena. Also, I also think that we can give tax subsidies to private persons who invest in these constructions so that the government will strike a deal with them. If they grant them tax subsidies and they construct certain buildings, they will reduce, or the government would have a say in the rent that will be imposed on those particular buildings. And lastly, on reading the bill, I realized that hostel accommodation is part of the definition of the bill. However, the provisions of the bill are scrupulously silent on the relationship between occupiers of hostel and then the persons who give it out. We don't know whether it's a landlord-tenant relationship or what. And then the only provision on that is that owners of hostel accommodation should issue rent cards to the occupiers. But what is the essence? How does it help to regulate the astronomical hostel prices that we are experiencing these days? So those are some of the things that we'll have to take into consideration even as we discuss the bill. Thank you.
Thank you, Martin. Thank you. Thank you. So, ladies and gentlemen, we would like to thank our panelists. Her Honor, Mrs. Gloria Benson Bonsu, Professor Divine Ahiaje, Professor Resford Asasi Opon, Mr. Kwajo Ajebio, and Mr. Kakraba Ampem. And my friend online, Mr. Frank Abuaje Nyansa, who joined us from Netherlands. We'd like to thank all of you for your insightful contribution. And audience, thank you for making the first session an interesting one. I'm confident that the second and the third session will even be more interactive. So shall we give ourselves a big round of applause? Yeah, so please, we have our snack break, and it's for 20 minutes. 20 minutes. So 20 minutes time, we reconvene here. Now we start the real work. They know themselves.
Hello? Thank you, ladies and gentlemen. We would like to commence the second session. We will therefore call on all those outside to come and have their seat. Please, all those outside, you are kindly entreated to come inside and take your seat. We want to commence the second session. Please, let's all those of us outside kindly move inside and take our seat. And at this point, we would kindly call on the panelists for the second group to kindly move upstairs and have their seat. Members for the second panel. Thank you, Doc. Thank you, Lawyer Hans Kodia. Thank you, sir, for taking your seat. I'll hand over to the lead facilitator at this point to take over. Thank you.
Thank you, Madam MC. Shall we give our second session panelists a big round of applause to welcome them? So our IT people, please get the online ready. We have some of our panelists online. We have one panelist online from Gambia, Republic of Gambia. So without wasting time, I will introduce my panelists and then we begin. So to my extreme right, we have Dr. Samuel Boadi Adakwa, Faculty of Law, KNUST-TEK. My immediate right, we have Mr. Hans Kojo Kodua, Faculty of Law, KNUST-TEK. To my extreme left, we have Mr. Jonathan Zinzi Aite, Senior Lecturer, Department of Land Economy, KNUST-TEK. To my immediate left, we have His Honor Mr. Fred Obitre, Circuit Court Judge and Additional Magistrate, Kumase. Online, we have His Lordship Justice Osei Tutu, Justice of the High Court, on secondment to the High Court, Republic of Gambia. Shall we clap for him as well? Yeah, so as we indicated in the morning, the focus of the second panel is to look at specific themes from the Rent Bill 2022. So all interrogations, critique, comments, suggestions will have to be tailored around that. And when they are done, we will invite you to make your contribution. Yeah, so we'd like to find out, you haven't gone through the bill before this session. Before we get into specifics, do you think that some matters need to be included in the Rent Bill 2022 but have been omitted? Maybe I'll start from my Lord.
Yes. Not necessarily matters that have been omitted, but there are a few matters that have been included that appear to be creating problems. Will create problems of implementation and also create problems of unfairness. Now, as my sister in the earlier panels spoke about, Clause 10(1)(a) of the bill allows the magistrate to take account of inadmissible evidence in deciding a case brought before him or her. Meanwhile, Clause 9 of the same bill says that a rent magistrate sitting as a magistrate sitting as a rent magistrate has the same powers as a magistrate and also will observe the same procedure as a magistrate. Now, the procedure that a magistrate observes in the performance of that magistrate's normal duties is we take account of only admissible evidence. And therefore, you will realize that Section 9 and Section 10(1)(c) are loggerheads. 10(1)(a) are loggerheads. And therefore, my suggestion is that Section 10(1)(a), which allows the magistrate to take account of inadmissible evidence, should be taken out so that the statute to be consistent with the Evidence Act on that part. Then, I have an issue also with in Clause 21(3). It suggests that where a landlord intends to remodel a premises or reconstruct or feels that the premises is deteriorating and needs to do renovation, there's a precondition there before the tenant can be removed. That is either the lease or the tenancy might have expired, or the tenant must have become a statutory tenant. Now, the question that arises is that where there's evidence that the building is even deteriorating, so long as the tenancy has not expired, the tenant is willing to continue to stay in, then the magistrate cannot order recovery of possession. I had a practical experience, a case from Bantima, that when I visited the locus and saw the building, I was convinced and I agreed that it needed renovation. But the lawyer for the tenant argued that the lease had not expired, and therefore they will not move out. And indeed, that is what the law is saying. And therefore, I suggest that that clause, it should be removed to just make it a condition that where there's evidence that the building needs renovation or needs to be reconstructed, then the tenant could be made to give away for the reconstruction, because there are safeguards. The safeguards are that when the reconstruction is done, it is that tenant who has the first right of reoccupation, and therefore injustice will not be occasioned to the tenant. So that is my suggestion on that part too.
My Lord, before we come back to you again, Mr. Hans Ojokodua, Do we think some other matters need to be included in the bill but have been omitted?
I've carefully looked to the act, but I think that majority of the provisions were removed from the existing Rent Act. I do not think that anything has been left out. I rather have an issue or issues with some of the incorporations. Some new matters have been incorporated into the act. When at the appropriate time you give me the opportunity, I'll comment on them. For me, what is here is okay, except that we need to own some of the provisions, at least to ensure parity of justice for now.
Thank you very much, Mr. Kodia. Mr. Zenze Aite, if we look at the bill, one of the 9 functions that have been assigned to the Rent Management Department is to operationalize National Rent Assistance Scheme, what I call the NRAS, which is contemplated under clauses 12, 13, and 14 of the bill, to provide low-interest loans to eligible Ghanaians so that they can access affordable housing. Now, I'd like to find out, first of all, whether in your considered view, the National Rent Assistance Scheme is a good invention in our law. And if it is, if you look at the current rendition, the intended beneficiary is supposed to be a Ghanaian or only Ghanaians. And I would like to find out whether it should not rather be for residents in Ghana, because you could be resident in Ghana for many years, you've not necessarily nationalized or become a Ghanaian, and if you fall within the intended low-income category, shouldn't you be a beneficiary? What are your thoughts?
Thank you very much, Dean. Unfortunately, you didn't give me the chance of the first question that you asked that we were all having a bite of, but if you permit
No,
me,
I'll allow you, please. Go back before we come.
Very good.
Right.
That's what I want to do. I look at the long title of the bill, setting out a lot of interesting things to do, but unfortunately, I was disappointed looking at the provisions because I realized that the provisions does not really address the issues that the long title purported to solve. So that's my first comment over there. In all, I feel that the act is to regulate rent, which to me was a bit disappointing. But there were good things there to remove the inherent constraint in housing supply. So I was looking out for something that will actually push the supply side, but I don't see anything. So I feel that's something that has to be looked at. Now, to protect the low-income and vulnerable tenant from abuse and arbitrary action, I think to some extent that is where this provision of housing subsidy come in. In principle, that's a good one, in principle. But it is the implementation that will help us to see whether it's really going to solve the ill that it intended to. In principle, it's fine. So then, if the financial institutions or whoever is to implement this is given the right incentives to do it, then it doesn't necessarily matter whether you are a citizen or you've lived in Ghana for long or you are a resident in Ghana, because what it will mean then is that there will be a procedure to find out whether you are eligible. Now, when you are eligible, then that's it, because currently, even when it comes to mortgage loans and the rest, it's not an issue of your nationality or things like that, ability to satisfy the requirement. So my point on that very one is that it's a good principle. It's a good approach. However, how we couch the implementation will help us to see that it shouldn't be only citizens, but resident Ghanaians that qualify should have access to it.
Right. Just before I go to Dr. Bodia Dakwa, and then I'll go to my Lord Justice Osei Tutu. IT, can you confirm it's online since I'm not seeing? Just to say to two. Can you let me know when he's online? Now, you raise a point, and I look at the long title. If you look at of course, we are not being extremely legalistic here, but the long title is supposed to say like the purpose or the objective of that law, and it plays key role in trying to interpret any interpretive matter which arises. You talk about the reference he made to the supply side, but then if you scrutinize the clauses, you don't see anything which really addresses like the supply of yeah. And I agree with you. So will you agree that addressing the inherent constraint on housing supply is not appropriate for the rent bill, and probably to go to the Ghana Housing Authority bill, especially so if you look at the clauses in the bill and you don't see any attempt to provide such a panacea.
Exactly so, because there are a lot of policy steps that can be taken to enhance supply. Our government over the years has attempted to do that, but unfortunately, they are missing it. I think the reason why they brought it here is this. One thing that we have lose out on is talking about affordable housing, and all we think about is ownership, which actually, when you talk of housing, is wrong. Housing doesn't mean ownership. It's just a part of it. So I think that, yes, the issue of boosting the supply side can be moved there. However, it can also be done here. Some of the provisions here are rather inimical to encourage supply, because in the morning we talked about concept and philosophies and things like that. But however, where we have gotten to now, and we discuss here, invested, you ask yourself, why does NEET, for instance, stop renting out houses? Why did they sell them out? Because that market need to be protected. So if you come here again and regulating the rent, putting capital on it, you are not encouraging people. I go and solicit loan to invest in housing. Affordable over there doesn't mean that you regulate how much I charge, but rather there can be other incentives. Bring those incentives here. But holistically, there must be concrete provision in the rent, in the housing bill, that will encourage supply. But that here is not done.
Build,
so
right.
Let's rather make it here possible for suppliers not to feel being controlled, to forget about the market, but someone else to determine what they should collect as rent, named Christine Recoverable Rent. I'm sure we'll get there.
Yeah, but I was going to go to Dr. Dauka, but in the morning, the panel, the issue came up quite forcefully that when it comes to housing, it's a social commodity. And since it's a social commodity, should it be just left to the market forces of demand and supply?
You see, that is where the social aspect can come in, because there are some that need to be protected. You target them, and if you agree with me, in other jurisdictions, it is the local authority that make some kind of provision even for them, or you use planning and tax to encourage people to provide for those class of people, but not to do it from the back door by regulating the rent. So you give developers through planning regulation that, okay, you know what, you will develop, but giving you the permit, this percentage of it should be for this class of people. Then because you are providing that, we'll give you tax incentives also and so to provide for those kind of people. Because there are some that will operate in the open market and they will pay because they need that facility. So the issue of social, agreed, but that must be targeted and provided for not through this, but through other incentives that can be given to the supplier. And it has worked elsewhere very well.
All right, thank you, Mr. Aite. Dr. Adakwa, just your thoughts concerning the National Rent Assistance Scheme. Is it a good concept? And if it
Yes,
is, do you agree with some of the points that the society has canvassed on that particular issue?
Yes, absolutely. I think it's a very brilliant idea. Any policy that attempts to help people who are not able to rent in this country to rent is a good policy. Its implementation is what we should look at. So if you look at the bill properly, so could you see that the approach is government and private partnership. So how do we regulate the private entities coming in? So for example, once private entities are in, we are looking at profit. And when profit is involved, we must make sure that the people we are trying to protect are not worse off than they were, so that we don't lead people into bankruptcy through the loan process. Because certain loans are not loans that are good enough for some people to take. So we should be very careful in who we bring on board in terms of private sector participation. That is what the word of caution I would like to sound. But ordinarily, if the policy is to help people rent, that is a good policy. Some people don't need too much money to rent in areas that they are, but they cannot just come out with those monies. But if they are given the assistance, they may be able to do that. So 10,000, 20,000 for 2 years advance, if the help is there, that is a good idea. And also we should eschew giving loans to certain group of people. Because if your rent is 20,000 Ghana cedis a month, I don't think you qualify. We should look at people's rent at 100 cedis, 200 cedis, 300 cedis. These are the people we should be looking at. And that is a good idea if we support people in that area. Then also, before I let you take over, the first question you asked, you posed, I would like to contribute to it. So the bill says that, at a certain point, says that there is an emerging technology. And through this technology, people are able to rent their properties using Airbnb, the internet, so Airbnb. So these are short-term rentals. These matters to be regulated by the bill. I was looking for specific provisions. I could not find it. So if we want to treat these matters as leases, properly so-called, and not licenses, then we should make it clear. Yes, so that we can regulate them properly.
Yeah, but with respect to the Airbnb and its related products and variants, the argument will be that, well, some of these land laws, they target tourists, foreign tourists, and these people are coming with the hard currency.
Yes.
So the lawmakers should allow them the room to be able to cash in on tourists who are not so much worried, because where they are coming from, the kind of rent you'll be asking for the short stay is not any big deal.
Yeah, that is true. But the act said that it was going to regulate it. Now, we don't see how it is doing that, the bill. We don't see how it is doing that. But I'm saying if we want to go there, then we should take a critical look at it. Do we see this as a license issue, or do we see this as a tenancy? Because if it is tenancy, then we are bringing in the provisions that protect the rights of tenants under this bill. And that is where we should sound the caution.
Right, thank you. Now, before I come to Justice Alexander Setutu, currently at Gambia, I think there's this aspect I need to bring up. The Ministry of Gender, Children and Social Protection, there's a law they've been working on for the past 3 years. I don't know what that is going through, but it has to do with the social protection bill. So if you look at those who are supposed to benefit from the National Rent Assistance Scheme, we need to also make sure that beneficiaries of intervention like LEAP and so on, how do we actually factor some of these low income or even those who are not even earning anything? How do we bring them within some of these social safety net? Now, Justice Osetutu, if you look at, I don't know, is he, okay, we don't have him yet, right? Since we don't have him yet, we'll come back to him. But Dr. Adaka, I'm on you again. If you look at clause 39 of the Rent Bill 2022, it seeks to prohibit terrorist act by tenants. My concern is that is this provision in the rent bill really appropriate? Particularly so when we know that in the Anti-Terrorism Act 2008, Act 7 says so, it creates specific offense. Why should we bring the offense of terrorism in a rent law?
When I saw a section, the clause 39, I was like, wow, why do we need this? I'm thinking the lawmaker is making emphasis. He's trying to make emphasis here that henceforth landlords know that you have to do a background check of the people you put in your houses. So that if these people are not desirable, they are people who have association with certain elements that want to cause trouble for the nation by way of engaging in terrorist acts, these people are not welcomed. So there's an obligation. If you look at the bill, there's certain portions of it says that a landlord must make inquiries, ask certain questions about people who are coming to stay in their house, to know that these people are desirable or are genuine tenants who are not in to foment trouble for the country. I see where the lawmaker is going, but it is quite out of place that it is put in the manner that it is couched. Because this is part, if you look at Section 17 of the Anti-Terrorism Act of 2008, you will see that if you lease your property to a terrorist, you commit an offense. And the penalty provided for in that section is the same as provided for here. So what I see is that the lawmaker is trying to make emphasis that don't rent to certain people. But then if you go deeper into the law and you look at the enabling provision that helps the landlord to make inquiries, you see that doesn't go far. It just says that you should ask certain questions about the prospective tenant, and that is all. So we should empower the landlords to have the power to do more, to ask more about people who are renting from them. In that sense, we can meet the law's requirement.
Now, in that regard, will you agree that this rent bill should also anticipate provisions of existing enactment like the national identification? You know, now we have a national database, so that should it be a requirement that if you're a landlord and someone applies for to rent a room, you should insist on the person producing national ID, in which case background information will be readily available.
Yes, to the extent that we want to prevent certain people from renting, if that power is given to landlords, and if people are made to produce identification. If you say, I'm Mr. XYZ, I want to rent your building, show me proof that you are XYZ and that you are not going to use my house for terrorist activities. That is permissible. But when we start doing that, then we are also opening the door to other legislation. So, for example, not too long ago, we had the Corporate Insolvency and Restructuring Act. The purpose of this act is to rehabilitate businesses that are failing. So we have what we call the restructuring and then liquidation. So if a business needs its premises to reorganize itself, then do we make those provisions here in terms of rent so that landlords are not able to evict companies that are struggling?
Oh, right.
So when you do that, you open the door, then many things will start flowing in. So we need to be careful in how we put in certain specific provisions into the bill.
Yes. Yeah, thank you, Dr. Dakwat. Mr. Hans Kojo Kodua, if you look at the rent bill, among other things, it was about the rent assessment. And no doubt, rent assessment involves some technicalities. Is it a good idea to involve rent magistrates? The rent magistrates who are often ordinary district court magistrates with no technical competencies in the nuances of assessing recoverable rent. Shouldn't we reserve that for land economists and other people who appreciate some of these complexities and market dynamics?
All right, thank you very much, sir. A minute back, if you look at what my colleague just said, where a terrorist, for example, is involved, I do not understand how even a magistrate can sentence someone to 25 years. Does the magistrate have jurisdiction to do that? And that is the punishment here, not exceeding 25 years. Can a magistrate put somebody in prison for even 10 years?
No.
So they have to look at that one. They shouldn't create jurisdictional issues for the court. Now, that aside, you're asking whether a magistrate can be involved in the assessment of recoverable rent. Well, it is possible, provided the magistrate could be trained. We have commercial courts, we have land courts, we have labor courts, we have gender court and the rest. So if every rent matter should go to any magistrate, then there will be a problem there. But if we can have a specific court where magistrates are trained, then I think it will be appropriate. But looking at context now, I do not think that we need to reserve that responsibility to magistrates because they don't have that technique to determine how much a person should pay, taking into account A, B, C. What are those things that you need to take into account before the rent is assessed? So I think that giving this responsibility to magistrates is not appropriate. We could train people to undertake that responsibility. The magistrate may be there to enforce those provisions, those assessments which have been made by trained, competent personnel of the department.
Right. So therefore, the rent management department should be manned by those who technicality lies in those matters, so that when it comes to assessment of recoverable rent, they will do that.
Sure.
And if the rent magistrate will come in at all, it will just be whether there has been due process in terms of procedural justice,
Exactly.
rather than substantive computation.
Yes, that's right.
Yes. Mr. Fredo Bitre, my lord.
Seems
Yes.
we are missing the point here. Under Section 1141 of the Evidence Act,
Yes.
it allows a court to appoint an expert where a court is deciding a case and feels that I need a land economist. We do it every day. The surveyors, most of them are not judges. And judges, if you are even a surveyor by training, you cannot descend and go to the field to go and look at anything yourself. So we appoint surveyors. And one experience I want to give you is the first election petition case. The Supreme Court will not collate the pink sheet by itself. Yeah. They have to appoint KPMG to do it. So when the act says a magistrate to assess recoverable rent, it doesn't mean that the magistrate by himself or herself will take paper and pen and be doing any investigation. We will appoint an officer from the rent department who will go and do it. In fact, I did it recently. When I was about to deliver a judgment, I realized that I could not assess the rent. I appointed the regional rent officer to go and do the assessment. And when he brought the report, I made the report be served on the two lawyers, and they interrogated him. After that, and I gave my judgment. Are you getting the point? So when they say magistrates should assess recoverable, it doesn't mean that it should have the competency. In any case, a rape case, if the judge is even a medical doctor, he cannot determine those technical
that the hymen
methods
is broken
by himself. He has to get a medical doctor who will come and stand in the box. Are you getting the point? So that is it.
I'm sure Mr. Zinzia
Yes.
would like to have
a
it, but
bit-
not on the last one I said, but what my lord is saying.
Yeah, forget about
All
that
right,
one.
very well.
That one is very much on point. The issue
Yes.
is, I agree perfectly with him, but that will happen if there is a controversy, if there is an issue. Because when you look at the provisions of the Act, the rent officer is primarily mandated to do the recoverable rent assessment. The reference to the rent magistrate to assess recoverable rent will be a referral. So, of course, what he said will come in. But my problem even is that we are trying to see how a thing will be determined when that thing itself is prima facie non-existing. What I mean is that the concept of the rent, recoverable rent is not there. It's not applicable in the system we find ourselves in. This is one of the concepts that was picked from the 2220, the
1963, right.
It is something that is picked here, there, and put here. Because if you look at the interpretation section of the Act, and you compare it to how that recoverable rent is to be determined and everything, there is confusion. It means then that maybe technical people on that subject maybe were not effectively involved, or they were just picking what used to exist. Because the two definitions does not click. I think the provisions 13, 14, or 15 give us factors that should be considered in determining that. And those factors are not applicable today. No valuer use rate payable, property rate, to determine rent. It's not done. So a lot of things have been listed there which doesn't exist. And then you go to the interpretation section, then they go and mention there that comparable methods should be used. The two are not the same. And speaking from surveyor's point of view, or a valuer point of view, we have other acts that make specific reference to a valuer. For instance, if you take the Borrowers and Lenders Act, it makes clear specification that when there is a need or when you want to enforce your right as a lender, get a valuer to do the valuation before you go ahead, and the court will come in and think. Now you come to rent, you make use of a term, recoverable rent. It doesn't exist. It's market rent.
Market rent?
Yes. It's market rent. We do more have anything called recoverable rent, because in the interpretation even shows that no, that is not what we mean. So what we are addressing itself is faulty, and the procedure we are using also have hitches. So that whole area needs some.
So you suggest that this whole concept of recoverable rent is more or less anachronistic, and it should be taken out of the new bill?
It should be taken out, and if there is a need, market rent is what should be used. That initially should be determined by a valuer. If there is a dispute, then we can escalate to the magistrate and the rest as it's indicated. However, the provisions on that also is faulty. You can't say that there should be determination of market rent before a tenancy agreement can be reached. Determination of that is a contract. The tenancy agreement itself is a contract between two people. So the regulator here will just be there when there is a problem. And then also to ensure that people are not, if I should
exploiting the vulnerable.
Exactly. But to say that that must be determined before rental can be.
I mean, that being the case, will you suggest that if it's not going to be in the primary legislation, if we look at clause 46, clause 46 or so, the minister is empowered to come out with an LI to make provisions for operationalization of certain aspects. So will you say that within that context, the LI, for example, should provide for maybe table of market rent or whatever appropriate designation we use for certain zones of residential area, so that if you go maybe like the zone A, not until there has been an update, depending upon the developments on the ground, this is like the range of rent. And if there is any dispute regarding the tenant saying that the landlord or landlady is overcharging, we can readily have regard to such data. Of course, that data can be updated periodically, but it's readily available. And the rent magistrate, the rent officers, and all that will have something that they can have recourse to around the clock, rather than having to go into the nuances of case-by-case computation of what the recoverable or market or the applicable rent should be.
That could be a possibility when we get there in the LI. So then the point is that it may not need to be in this primary, but then in the LI. The only challenge you'll be facing there is that you and I can be occupying two adjacent buildings that are two-bedroom. But your taste and what you ask the landlord to do for you may be different from mine. And we have a tenancy agreement. In that tenancy agreement, we have people at arm's length that have discussed and said that this is what we will do and so, so, and so. If you give a base rate, there can be a base rate. But when you try to set a ceiling in such a market, you are not being fair to the market. When you say that I want to encourage supply side, and I have people with good taste that need this, that, and I provide it, and you give me that, I can charge above this. Whilst that is what the people want, and they are willing to pay for it. So that brings out the question also is that if you want to protect those who are below a certain income level, who are just interested in the basic, you can do that there. But to legislate generally and say that this is the rent for this area, you are trying to manipulate the market, and economically that may not be well. So there can be a balance. Yeah, so if I understand you, the one-size-fits-all approach in trying to legislate landlord-tenant relationship is a wrong approach. And come to rent. Very well. Okay, right. I come to Mr. Fred Obitre, the Circuit Court and the Additional Magistrate. If you look at the Rent Act 1963, Act 220, Section 17 thereof provides a tall list of circumstances that may justify recovery of possession and adjustment. Are there any cases concerning landlord-tenant in which the provisions under Section 17 created complications and injustice to the landlord or tenant concerned? So we want to get one or two cases where we can say that the regime for recovery of possession or ejectment under Section 17 of Act 220 is really, really problematic. And for that matter, in the new bill, we should come out with a panacea which effectively addresses that problem.
Yes, I think I gave a hint about that already. Under Section 17, 2 or 3 of Act 220, one of the requirements or the major requirements for taking out a tenant where the landlord intends to remodel or reconstruct the premises, as I said, as the case may be, is that the tenancy must have expired, and then the tenant must have become a statutory tenant. Now, so when it happened like that, it has not expired, and the tenant is not a statutory tenant, the court cannot eject the tenant for any reconstruction to be done, as I said earlier on. So that is where I feel there's a problem. So I was suggesting that those clauses should be removed, and rather we should concentrate on evidence as to the need for the renovation. And to get that, we could contact the experts, appointing the experts to look at the building to see whether indeed it needs to be renovated or if it needs to be remodeled. I think that's my observation on 17.
Right. Thank you. Mr. Hans Kojo-Kodua, are there any cases concerning landlord and tenants in which Section 17 of Act 220 prove problematic?
Yeah, thank you very much, sir. What we have here is almost the same as what used to, or what exists now under 220. I think that there are two issues here that we need to look at. Now, if you look at section 17, for example, we are talking about justice. I remember I had a case with lawyer Kwambuafo in 1996 at the Magistrate Court, Ashtown. I remember I charged the client 20 cedis. At that time, the matter persisted for 10 years.
20 Ghana cedis or
20 Ghana cedis.
Right.
In 1996, the matter it was after 10 years, the case was still pending. So I called the client and said, please, I'm sorry, I can't continue the matter again. How much did I charge you? He said, 26. I said, I'll give you 100. You know, take your matter away. It was a single room matter. So the problem is, if from this, now the matter went to rent control, and then it was referred to the rent magistrate. And then there had to be an appeal. There was one that appeal even from the magistrate court traveled for 20 years, chamber and hall. So the problem is we need to, first of all, limit the jurisdictions of the court. For example, it could be put into this particular act that after the High Court even has sat on the matter as an appellate court, the matter should not travel further. Because single room, 10 years, the case was still there. Ashtown, traffic. So I repented and handed the file over to the guy. So I think this is one of the issues. Single room, 20 cedis at that time. Now, let me quickly add this one that if you look at the subsequent provisions, the relationship between a landlord and a tenant, some of the non-compliances have been criminalized. That if the landlord, for example, fails to provide information to the tenant, it constitutes a criminal offense. I don't think that in 1963, the concept of criminalization and punishment, probably for some reasons, were incorporated. I don't know whether it was to ensure, statutory compliance or whatever, but I think we have gotten to a stage where we don't need to think that putting somebody in prison is the best option. You are talking about your landlord and your tenant, and the tenant has, let's say the landlord has breached a provision. For example, for not providing with information that you demanded. Yeah, for example, rent card. And the law says the rent magistrate can put you into prison. Now, that is not an issue, but if the person goes to prison and he comes back, even when he's in the prison, the wife, the children will be visiting him. The family members will be visiting him. They'll be sending him some food. Do you think you will have the peace to stay in the house? So I'm thinking that from practice, I'm thinking that these issues of putting people into prison for breaching these contracts, a contract with the landlord and I don't know, these things should be expunged. Now, the landlord is the owner of the premises. If the landlord has committed any offense against the tenant can be compensated in monetary terms. Rather than putting the landlord in prison, you will rather generate problems for the tenant, even if the tenant is ejected. A son or a relative of the landlord will still chase you, the tenant, anywhere you go, for putting my father in prison. You see? So I'm saying that this provision too also should be looked at. We need to, for me, putting the landlord in prison for not complying with any other prison should be expunged. This was the 1963 concept. We can set up an arbitration committee, ADR, for example, to look between the two parties. Yes.
Right. Thank you. I think Dr.
Yes,
I want to say something.
Yes, I just wanted to add to what
yes.
Mr. Kodwe had said. So we must look at the time frame for some of these processes. It is, we can say that when you get to the High Court, there's no further appeal. The alternative is to introduce alternative dispute resolution strategies. So mediation, arbitration, negotiation.
But thankfully, it's
Yes.
incorporated in the
Act.
rent bill.
Yeah, so it solves some of
2022,
these
yes.
problems. When we will look at it when we get there. But I think it's a route to cutting the time frame for some of these
Yes,
cases.
now that you've introduced that, maybe let's hear your thoughts on it, because the ADR has been incorporated in the rent bill 2022.
Yes.
And no doubt it's a welcoming initiative, but the only problem is that we still have a tall list of offenses, as Mr. Kudia expressed concern. And
yes.
Of course, the punishment, the first line of punishment is actually a fine. And in default, then we have about 30 days of imprisonment. In Ghana, people are afraid of imprisonment, so that will probably encourage compliance more than...
Yes. I think that for ADR, incorporating ADR into the law is a good thing. A good thing in the sense that not all cases should go to court. Some cases can be resolved by just a sitting with some elders who the people repose confidence in. They can easily resolve these issues.
That's right.
And as we anticipate putting this in the law, we should also note that ADR must not be made compulsory, because it starts by consent of the parties. So if the parties do not consent to the arbitration, do we necessarily say that go for arbitration?
Maybe what is happening these days, what they call the court-connected one, where you go to court, but at the stage, it's mandatory that you go and exploit the possibility of the mediation or any other appropriate form of ADR.
Yeah, that is true. If you look at the commercial court, essentially that's what the commercial court is doing. So there's compulsory arbitration at a certain stage. If you are not able to resolve your issues, you go back to trial. But if you look at the trend in the Rent Act 1963, you see the concept of the statutory tenant. Issues of contract, matters that should be left to the parties being eroded by statute. And statute is taking certain positions that sometimes are inimical to the interests of the parties. So, for example, a statutory tenant, your time has ended. Your lease, you don't have a lease anymore. You entered into a contract. You said that I want to rent this place for 6 months, 1 year. 1 year is over. Landlord says that by our agreement, leave. Then you say that I'm not going. And this conduct is protected by the law.
Right. Right. Thank you, Dr. Dakwa. Unless otherwise, I was going to introduce the concept of statutory tenant so that we dispose of it. The concept of statutory tenant.
Cut you. But talking about the section 17, that's a second.
Yeah.
You see, the way the provisions are couched
on the recovery of possession and ejectment.
Litigation will be in the ascendancy. See, will be in the ascendancy. I think we need to look at, and we need to look for a regime that will promote peaceful resolution of matters between the landlord and tenant, rather than loading the court. Just a second. I did a case for a woman. The matter lasted for 3 months. He told me, lawyer, you had delayed the matter. 3 months is too much. I'm getting a tenant that I want to solve it myself. I've paid you. Take your money. Give me my file. I gave it the file. I said, wait for me. In 1 week time, I'll come and tell you that I've solved the problem. I said, how? He said, don't worry. You know what she did? This woman told me that, lawyer, in the evening, I'll go naked into the room. The man had married. The tenant had a wife. Then you go there and excuse me with my example. You go there naked in the room. Landlord, the tenant, I'm here. I'm going to sleep in this room until you leave. 4 days time she came. Lawyer, I told you your formula was wrong. I've gotten them out. Because the man could not stay in the room while the woman, the whole landlord, the landlady was, excuse me to say, naked in the room. And the man will leave. He will stay outside. If the man enters, he will even go and bring her mattress into the room. You see? So all these things are because the court will delay the trial. So we need to look for a regime that will facilitate informal resolution of the matter between the landlord and tenant. I do not support the issue of putting the landlord into prison for simply breaching a clause which is of commercial character. No, shouldn't be.
See, the other practical challenge we have in Ghana is that, unlike maybe a jurisdiction like the UK, where they have what they call the council houses and all that, if you have a problem with your landlord or landlady, the state does not have available, if you like, the temporary accommodation, which will have made matters easier. So that is the rare challenge that we have. But having said that, this issue of statutory tenants is a concept which is really, really controversial. And a lot of people hold the view that I erected my building or I financed the construction and all that. Why should a recalcitrant tenant be imposed on me? And then the law continue to protest such a tenant. And yeah, so what are your thoughts? Statutory tenancy, isn't it a concept which should be taken out of the law completely? I would like to get your thoughts on this issue because it's a very key matter in this law. Yes, Mr. Fredovice.
I'll ask myself, what is the purpose of that provision? Now, if you look at the Rent Act carefully, the Republic does not want to leave the tenant, the vulnerable tenant, wholly in the hands of the landlord because of the tenancy agreement or whatever agreement they have. That is why that concept is there, that where your lease EV expires, and there are certain conditions that must be met, like the landlord wants for personal occupation or the personal occupation of the relative or the employee, those conditions are not there. You become a tenant of the state on the same conditions, and you observe the same responsibilities as a tenant, as you have to observe under normal tenancy. Now, so that the law is a way of protecting the tenant. It is not the case that when you are a starting tenant, it means that you'll be in the accommodation for free. But what I also realize is that without that concept, people will be removed from rooms on a daily basis. That's the point. So it's a balancing act. It's a balancing act.
So you think that the concept should be retained?
It should be retained.
But maybe, I'll take other panelists view, and then I'll link it with the other clause.
The rate at which rent matters flow from the rent control department to the district courts, for instance, you realize that without any regulation, without any clause in the law to protect the tenants, especially, there will be floodgates or removals.
No, but the other point is also that shouldn't property owners, landlords and landladies, enjoy their property? For example, if you look at the university community, I'll not go far. Yeah. Within the neighborhood of the environs, a lot of landlords will find a way to get their property back and then redesign it into hostels, so that for that one, they are sure that within 1 year or within a month they get their money. Why not? Why shouldn't they enjoy from their property?
That is why the first point of the agreement, their relationship, is that there is a tenancy agreement. At that time, the state does not control it. Whatever understanding the parties reach at the time of the entry into the contract is not controlled by the state. The only requirement is that you must give a paper called tenancy agreement under the new bill. The state is not saying this is what you should agree on. But when you agree, some landlords scheme to remove tenants only because there's a potential tenant who will pay higher. The question is that fair in the welfare state?
I think that is opening the Pandora's box, especially so when the state has not provided money to anybody or tax rebate to those who are trying to build their own houses. Yeah. Then you go through all the trouble to build, and you want to take advantage of profit maximization with free market permits. Then the state says that no, we have to stand in your way. I think that is the crux of the matter.
Yeah, that is
yes.
Discrimination. I see it to be discrimination because here we are talking about an estate contract, a contract between the tenant and the landlord. The contract contains certain covenants or conditions, one of which may be that I want to stay here for 2 years. After the expiration of the period, if, for example, somebody is to be considered as a statutory tenant, meaning that he doesn't want to continue with the tenancy agreement anymore, I think you should be given a month or so to read. You know that your tenancy will expire in 2020, for example, February. Then you wait till the expiration of that time. And because the landlord cannot get you out, then you say, I'm a statutory tenant. I think that provision is unfair against the landlord. It should be removed. For some tenancy agreement, it is provided that your agreement will expire on this particular date. If, however, you intend to apply for renewal 3 or so months before that time, apply to indicate your intentions and for how long you want to. The person doesn't do so, and while the person is in possession, the landlord also has made some arrangements that, look, I need tenant money from this particular premises, and he had engaged someone in compensation that I will rent this one to you when this man leaves. And then this man's time is over. This man doesn't want to leave. You can't also take any advance rent from the person. And the state says this is fair. It is fair because the state is saying so, not because we accept it.
Yeah, but yes, and related to that, there's this example of a bank that I will not mention. In one of the cities in the Ghana, they have a property that they've rented. They are using it for their banking business. They are there. Then the landlady will go to them and say that give me more rent, then I'll apply it. And as we speak now, the bank has to pay. They have a rent advance of up to about 35 years. So now, if they decide not to pay, then the landlady will say, okay, I've taken money from this. So as soon as your term expires, it's not going to be renewed. And maybe because you build like the goodwill at the location and all that, you are sort of pushed to a tight corner and then you agree. So these are some of the difficulties. But I wanted to take us to clause 28. Clause 28 of the Rent Bill 2022 makes the point that a landlord cannot increase rent of the tenant unless he has made improvement of beneficiary use to the tenant and has obtained permission from the rent office, from the district rent office. Now, question is, so long as Ghana is not in wartime, we don't have any state of emergency, for which reason you say that the state should maybe intervene and manage things for the good of everyone. Is this provision fair? That if you want to increase your rent, you need to provide evidence that you've made some, improvement in the state of the building, and that should be confirmed by the district rent office before you can increase it. What are your thoughts, Mr. Aite?
So that just buttresses the first point that I made. And from the discussion, you can see that the aim of the act, one of encouraging supply, has been defeated. Because a lot of things that we have said now means then that they are not encouraging, is not the act in its current form, the bill in its current form, will rather create a disincentive to the supply side. This, in fact, I've written it here, must be expunged. Because prior to
28.
Yes, 28. Because prior to coming to this, I've searched a lot of the acts on rent. You won't find this. It was there. And then we said that it was in the 220.
No, this is a novel provision. It's not in 220.
There is something like that.
Right.
Over there. But the way it is here, you see, it's contradicting. It's contradicting because you mentioned that rent advance. Interestingly, the rent advance, they say now 1 year is provided here. For short term, they say no more than 1 month. Yeah. Something like that has been mentioned. Yeah. Okay. What practically do we see now? Practically on the ground, what do we see? We see 2 years.
Yep.
So you want to say that when the two parties agree on that 2 years even, it's a criminal act. But the two said that that's what we want to do. This rent increase issue, we see those rent advancement to be something that is exploiting the tenant. But in one way or the other, if you look at it from both sides, it prevents things like this. Because when you have 2 years rent and it has been agreed and paid, that landlord cannot come and increase. And in actual fact also, improvement of beneficiary use to the tenant has obtained permission from the renter. These are not in the market things that we use to determine increment in rent. So the basic thing is that this very clause may have to be looked at again or expunged. It will not help anyone.
Dr. Dakwa, you have some thoughts?
Yes, I think I agree with what Prof said. This is really heavy on the side of the landlord. What if I do the improvement and the permission is refused? Then what do I do as a landlord? So I want to increase rent. I do the improvement that is required of me, and then I go to whoever I have to see, the rent officer or the department. They say that no, we will not allow you to increase it. That will be too much, a burden on landlords. So as you have said, if this there's a way this must go, it has to go. Let the market determine some of these things. We can have a ceiling that in this area, this is the ceiling. But to say that you need permission before you can adjust rent, I think this is too much.
Now, there is a new addition to the law that, I think if you look at clause 40 of the bill, it requires that standard tenancy agreement, which will be provided by the rent management department, should be signed by prospective landlord and prospective tenant, and same be lodged with the rent management department. Now I want to find out, is this provision really practical, or should it be changed? Because if you look at it, if it should actually become law, what it means is that once the tenancy comes into existence, within a period, you are supposed to get a standard tenancy agreement, which embodies the essential terms of the tenancy agreement, signed, and then you send a copy to the rent management department. Yes, maybe I'll start from Mr. Kodua.
I think this provision is going to even burden the institution. Maybe, but the fact of the matter is, two people are entering into the contract. What it presupposes is that before they enter into a landlord and tenant relationship, they need to go for the form and fill. I think this will not even help the tenant. One, are they going to pay for the forms? If they are going to pay for the forms, then the purpose of the act is also defeated. The person is already down. And instead of helping the person up, you are even digging to even let him down more. So the question, my Lord was saying something that you could refer the matter, for example, to an expert. Who is going to pay? Who is going to pay? So let the landlord and the tenant prepare their own agreement. If there is any clause or provision in the agreement which is either inconsistent with the Constitution or an act of Parliament, and the matter comes before the court will deal with it. But for the normal contractual arrangements, teach the law of contract, freedom of contract. The parties have entered into it. This is my phone. If I bought it for 2,000, if for any reason I want to sell it for 1,000 cedis, the government shouldn't be bothered. We enter into the agreement, and then I go away. If in future it comes to the court that the landlord was cheating the tenant, then the court could intervene and probably make appropriate orders. So I don't think that going for the form, because when you go for the forms, you pay. It will never be for free. see, you go for the forms, you come and sign. The landlord is not even in town. The landlord will come next week, you also sign. And then maybe the tenant is even an illiterate, complying with the illiterate protection ordinance. You have to go and give it to them, the jurat clause, and all these things. To burden the tenant even the more. I think this provision, in my opinion, is not relevant.
Right. Thank you,
Dr. Dakwa. The question is, where are they going to keep all this agreement? Where?
That's the question.
So you mean you need all the
Maybe
tenancy agreement for all the people in Bomso?
They can scan it.
Where are you going to keep it? Where? It's practically, this is a huge burden for the department. Documents will be missing, and I mean we know how these things work in our administrative
Can I
sector.
just add something?
Yes.
Just to add something small to
all right,
this
then
one.
I'll come to mine.
I think the intention here is fine, but then the way it has been couched is problematic. Maybe what can be done is that a schedule, a sample of tenancy agreement should be annexed to this. Should be annexed to guide the parties in coming into this.
As a sort of template.
Exactly. Not that that standard must be filled. No. Terms are different. People enter differently and the conditions are different. That's why it's landlord-tenant agreement. And you see, the confusion here also is, if you look at the sub 3 of that, whilst this is trying to control housing, now they are saying that the standard tenancy agreement is for residential and commercial properties. So, Kumasi Mall is giving out one of their shops and things like that. They should now go to the rent out people, get a form or a standard, fill it, and go and dump it with them. So you see that the bill is a good initiative, but has a lot of work that need to be done to really achieve the long title.
Dean, a quick one, excuse me. Okay. Now, talking about a standard form, there's nothing called standard form. You see, let me give you an example, just a second. Now, we have the shopping mall here. Now, the landlord provides security. The landlord provides a lot of things, which may not be provided somewhere. The landlord says, okay, in the event where the main power goes off, I have a generator. I'll provide generator. This is how much you are going to pay. So a whole lot of things. So if you are going to provide standard form, are you going to take into account some of these personal details of a particular landlord? So let us liberalize it and leave it to the landlord and the tenant to engage in the agreement. That's the point I made initially.
Yes, Mr. Fred, which my lord? Yes.
I agree that the standard tenancy agreement, I want to draw your attention to the fact that under Section 35 of the Land Act 2020 up to 1036, there are requirements for the validity of land transactions written there. When you go to the back of the law, there are templates. There are templates. So if anything at all, let's better provide a template. But to talk as if it is not necessary at all to have for the state to create some requirement for an agreement. What happens in court is that when they do agreements and it's not written, the determination of what the terms are becomes a problem. And everybody lies. Who tell lies, this other tell lies. Then the magistrate or the judge is in the middle. But you must give a decision. So I think that if there's a provision in the nature of what happens in the Land Act is made here, I think it will be all right.
Right. So just before we go to the audience, I'm going to go around to all the panelists, and if you were to advise the lawmaker what you think needs to be in this law but is not there, or what must be taken out. Just 1 minute, Dr. Dakwa.
Yes, I think what we have here is a good attempt at solving the issues we are facing with, but it's not conclusive. So there was a mention of hostels accommodation. So many of our students here live in hostel accommodations. And this issue is not properly regulated. The Rent Act, or the rent bill as we have it, did not touch hostels. The only time we hear about hostel accommodation is when it says that if you are a proprietor of a hostel, you must make available a rent card to whoever you put in your hostel. So the question that I immediately came to my mind when I saw that is, well then, are you now bringing hostel accommodation under the ambit of the Rent Act? Because when you do that, it has other connotations. When you live in a hostel, you may have a right of occupancy, but you may not have exclusive possession. For the most part, you are a licensee and not a tenant in the proper sense of the word. So if we are to rope all our people, students living in the hostel under this law, what are we creating? So that, for example, a final year student comes to live in your hostel. He graduates, there's no job. And if he holds on and says that you serve him a notice to quit and he says that I will not quit, he becomes a statutory tenant. Is he protected under the law?
Right, thank you.
So that in all our hostels, if this is to go on, are we going to solve a problem or are we going to create more? So let's know what we are doing. If we are bringing the hostels under the law, let us make it clear and see how we regulate this. But if not, then I think we should leave it as it is and let the normal rules governing contract and licenses deal with that. That is what I want to see clearly done.
Right,
Yes.
thank you. Mr. Kodia.
Yeah, in a second, I maintain what I have said already, but by way of an addition, if you look at section 17, which we had looked at already, you will see timelines for appeals. This is the first time we are seeing that if you want to appeal against a decision in 7 days, you want to appeal against it 10 days, I'll be like, the times are short. You see, if my brother were to be the rent officer and had given a decision, and he wants to appeal against it, maybe at that level, lawyers were not engaged. The lawyer may want to have the record to study and see whether the client has any chance or chances of succeeding. When is he going to get that particular judgment to appeal against? And you are giving the person 7 days. The issue is, if it's a final judgment, we know as lawyers that you have 3 months, and after 3 months, you have another 3 months justifying why you could not file the appeal within the first 3 months. If it were to be an interlocutory appeal, you have 21 days. The question is, if the party is unable to file the appeal within the 7 days, one, does he have the power to apply for extension of time within which to appeal, or because he could not exploit the 7 days, his right to appeal is terminated? These matters should be clarified. Otherwise, the judges will be confronted with the issue. Because when you go to the judge, he will tell you that you were supposed to file within 7 days. You didn't file. I don't have jurisdiction as an appellate court. But these ones are limited. Their times are too short. Why don't we go by the normal 3 months, 3 months, 3 months, rather than 7 days? I've never seen one before. If we are talking about justice, 7 days, although 7 is very important, numerically it's important, but not for purposes of appeal, you know.
Right. So theologically, 7 is important. Good. Okay, Mr. Fred Ovichre.
There's a principle we all know called litigation must come to an end. Depending on the nature of the matter. Rent matter is not the matter that should be allowed to be lasting for so long. I agree, though, that the 7 days may be a little problematic, but it should not be too long at the same time. The only thing, apart from what I said earlier, that I feel must be added is that under clause 30 of the bill, the tenant is proscribed from creating a subletting the premises. But if he does that, there is no consequence. There is no consequence. So I suggest that subclause 4 should be added to 30. So that if you do that, in case you are occupying any part of the premises, you have to lose your right of occupation.
So if you sublet, you don't want to leave that to a contractual breach. So that's like the breach of the tenancy agreement. And very well. Right, Mr. Aite.
Yes. I also want to say that the ministry has done very well with this engagement, because as for the bill, it's long overdue. We need an act. So it's good that they've started, but then it seems there are a lot of things that need to be done. Maybe this is just one of them, and further engagement will be needed. One of that I've not mentioned or I've not yet had a chance of talking about is rent card. When I saw it, I was excited, because when I was young, I remember I was the keeper of that rent card. You send it to the landlord, the end of the month he signed, you send it back, then the next time you bring it. This era, contemporary time, we are still talking about the rent card that should be provided, and you don't provide it is an offense. Yes. I think that one should be out. That one is too much. And then also, there will be a need to let the bill speak to some of the existing acts. For instance, I was just looking at the
so
rent.
Before you move on, the rent act, if it's to be taken out,
the
rent card, will you suggest that there should be a receipt for payment, so that
that is why what my honorable said concerning the tenancy, as for the tenancy agreement, is needed to be in writing. But if all those things are there and everyone know, and we know very well that it's no more the practice, maybe in the rural areas, that they pay rent by the end of the month and things. If all those things are there, and at this electronic age, why would we make a rent card a statutory issue? If the parties decide to use a rent card, it's up to them. Right. But making it a law, and for not doing it, you are committed a breach. No, yeah. That should be taken out. And I was just landing on the issue that there must be the bill speaking to the existing act, because there are some of the provisions here that already the Estate Agency Act that was passed in 2020 has taken care of. Now you are burdening the rent magistrate, whatever, to now license to register those people, whilst they are to be registered by the Estate Agency Authority. So some of these things are there, but I think this is a very wonderful bill that needs to be encouraged. Fortunately, the current parliament still have some time. We need to continue with this engagement to fine-tune it quickly so that they can give us that before the end.
Right, thank you. And then the other thing is that usually when you have existing legislation you want to repeal and replace with a new one, it's the best drafting strategy. We have what they call the comparative table. So that we have like a table. Now, if we take section 17 of Act 220, what is the equivalent provision? Yeah, so that we can easily do the comparison and all that. Right, so thank you, panelists. I will reserve 10 minutes for audience to make inputs, because we are behind time before we take our third panel. But our third panel, the issues are very straightforward, so we hope that in a few minutes we should be out of here. Yeah, so, okay, right. And please, we want you to be quite snappy.
Yes.
Straightforward to the point. Yes. All contributors, so that we'll be able to finish and go. Thank you.
Thank you very much, and I'd like to congratulate the panelists for a good work done. I must say that, indeed, having this bill is timely. And what we are doing is also good. But it still comes back to me that having looked at it and having looked at the authority bill, I think there should be an amalgamation. I don't know how we're going to do it. But the point I want to make is that the way we are going, and to support Lawyer Kodia, if you don't take care, people will stop constructing houses. Because the reality is that government, as of now, is not building. Individuals are building. We hope that the Ghana Housing Authority Act will bring this government position to provide housing. For housing is a process. It's not an end in itself. It's a process. And therefore, the tenancy agreement, that the standard thing that has become more or less contentious, I also want to support it that for now, it should be expunged if possible. Because if you go to the UK, tenancy agreement is sold in the shop. It is sold in the shop. So I, the tenant, or the landlord, I want to give my house to you. I go and buy that tenancy agreement, and then we sign. You keep a copy, I keep a copy. At the end of the lease period, whatever I have to do, we do. Those of us who have been there, Dean, you have been there, the house that you lived in, they will take money from you and put it in the bank. And at the end of the day, whatever interest that is accrued on it, you get it back. So it's a win-win situation. But if we create a law that will make the landlord suffer, Dean, I think we need to look at it.
Thank you, Professor Sasi Opom. Please, we are behind time, and we have another panel. And the university chaplain to do the closing prayer has already entered the room. So we need to hurry.
Thank you very much. I think I wanted to contribute to the statutory tenancy issue. I think it's a very bad law. It should be expunged. But we can also incorporate a provision in that regarding period of notice. So, for instance, they have signed a 2-year tenancy agreement. Then the Act can require either of the parties who intend to terminate the tenancy to give a notice to the other party, maybe 3 months or 4 months before the tenancy expires. In the absence of that, then the tenancy continues as a continuous tenancy. I think that would be a fine provision. And then regarding the rent increase conditions, why do you want to impose a restriction on that? It should be determined by the market. So at the end of the tenancy, market forces should determine whether rent should be increased. But in order to avoid a arbitrary increase in rent, then the law can make provision up to some limits. For instance, over a period of, say, 1 year, you can increase rent by more than 2 or 3 times, and rent increases cannot exceed a certain percentage. With that, we can deal with those issues. And then on the issue of the standard condition, yes, we can have it. But it should be restricted to standard terms of a contract. For instance, if we envisage that in the tenancy agreement, water and electricity should be provided, then those should be captured under standard conditions. Everything else should be negotiated between them. It's a contract. It's a private contract. Why should the state regulate private contract? Rent should be determined by the market, in my opinion.
Right. Thank you. I didn't want to add this, but because I'm also a teacher of law of contract, I have to remind audience that if you look at the concept of freedom of contract, it has not remained pristine. It's undergone modification because the state needs to protect certain interests, protect those who have inequality of bargaining powers. So we have to, and of course, today too, the point has been made about the social contract, like between the state and then the citizenry. Once you've agreed to be part of the state, we have to know that there are certain trade-offs. And the state, as a responsible entity, mother and father and everything, must also protect its vulnerable. So we must have all this at the back of our mind. Okay, so let's take, yes.
Okay, please, my point is on the offenses. As a prosecutor, I'm always interested in the offenses. It can be gathered from the discussions of the panel members that the imposition a prison term is a no-no. That I agree with you. But I believe that some of the breaches in the Act, decriminalization of the breaches will not be the best. And even in those cases that we are supposed to criminalize, I think that the fines, there should be an imposition of a fine instead. And the imposition of the fine should be such that it will be deterrent. For instance, I realized that section clause 37. That's the offense for the inducing a tenant to quit. I want to refer to the example that Senior Kodia cited, that his client decided to evict the tenant her own way. In such situations, I think that there should be an imposition of a fine, or even imposition of a prison term. And in such cases, I think the Act should look at the maximum fine or imposition of a sentence that will be given, because I think it's too lenient. For instance, you realize that the maximum shouldn't be more than 100 penalty units. When you calculate, a penalty unit is 12 cedis. So no more than 100 penalty units, it means the person is just going to pay 1,200 Ghana cedis. Somebody who has an intention of evicting a tenant to collect a rent of, let's say, 2,000 Ghana cedis a month will intentionally do so, and if he or she is fine, he gets to pay only 1,200 Ghana cedis, and the person will be free. So I think you have to look at the maximum penalty units that are supposed to be paid.
Thank you. But before we take Mr. Bio, I think the penalty unit has remained at 12 cedis for a long time. And it's good that Attorney General is here. So we are sending it through you to Honorable Godfrey Dame that they should review the penalty unit so that the offense will be more, the punishment will be deterrent enough. So it's not so much about the penalty units prescribed here, but it's about like the scale. So for example, if you review it and say the one penalty unit is 50 cedis, now it will let the value go up. So Attorney General, you have the solution. Go and revise the penalty units. All right. Yes, Mr. View.
Thank you. I said that briefly, but I don't know if same has been discussed on the appointing powers of the president in this very act. If you look at, I think, section 5 of this act, the president shall, in accordance, appoint. With respect, I think the president needing to be included here. We should allow our institutions to grow. That's allowing for entities within the rent sector to also allow for their personnel to develop within the system, rather than having the president to always be appointing. So I think that if the president removed, same would be good. Yes, thank you.
Yeah, thank you. And what Mr. Bio said is a confirmation of a recommendation, African peer review mechanism, as well as the Constitutional Review Commission. These two entities have made that if you look at Ghana's constitution, the appointing powers of the holder, I don't account by any particular president, but like by whoever holds the office of the president is like yes. So, for example, we have like the sector minister. Why can't the sector minister, for example, appoint this, and you have to let the whole head of state and so on do that? Yes. I think Dr. Sondem narrated some of the students. Yeah.
One and paragraph 4, there seem to be some, for example, in paragraph 1, it talks about the protection of low-income and vulnerable tenants from abuse and arbitrary actions. Okay. That is the focus. Now, when you come to paragraph 4, the National Housing Policy emphasizes that the state shall promote a progressive engagement approach to ensure that tenure conditions are improved for all, irrespective of income or social class. I don't see how you can marry the two. I don't see how you can marry the two. And in any event, even if we take the first one, how will the court determine whether a person falls within the class of low income or vulnerable groups? Is the bill targeting only those who are in low income or those who are determined to be vulnerable? That's one concern. My second concern is, if you look at the argument so far, My friend Kodria seems to be promoting the laissez-faire policy. And others think that there is the need for governmental intervention, at least to help the poor. The talk, what we are dealing with here, it goes beyond, it's about a question of what? Development. The state has an obligation to provide housing. The state is now checking its responsibility and giving it out to the private sector. Shelter is a socioeconomic right. And if you look at this, progressively, these rights are to be provided progressively because there are, we have resource constraint. And that is why the progressive realization of socioeconomic right is emphasized. The state has a duty. If you look at the right to education, we started with what? Free primary compulsory education. Not so. We are now in the second.
Secondary.
And the ultimate objective is to have what? Free tertiary education. Yes, that is the objective. We move a step. We started from primary compulsory education. We moved to secondary. Our ultimate objective is to have what? Free tertiary education. And so that is how socioeconomic rights are enforced. Housing, it is the responsibility of the government to provide shelter for everybody. We know that because of resource constraint, the government cannot do so. But the government still has a duty to take steps. And one of the steps is to what? To partner with the private sector in order to realize these objectives. And so if you are looking for partners or partnership, you don't have to overburden the partner. And so I agree with my friend Kodria that...
All right. Yeah, so let's take 3 more, and then we will take the next panel, and we leave here.
Okay, thank you very much. My concern is that it is my understanding that anytime there's an opportunity for an existing act to be amended, one of the resources that we need to fall on is what the existing case law has brought up as the challenges. When we know what has happened, it helps us to know the parts that we need to touch. Now, if you take the Act 220, the Section 36, the interpretation section, which has also been put in this exact formulation now about the landlord. The question of who a landlord is, it's a big problem. It is a big problem where there is a landmark case that a simple landlord-tenancy matter has traveled all the way to the Supreme Court for the Supreme Court to determine what the landlord means. What the landlord means. And the definition of the Supreme Court per Act 220 is that the landlord is the person who has a beneficial interest in the property. Said that if someone is a trustee, he cannot come under the rights of the Section 17 to evict somebody. Now, the practical effect of that is that if someone has a house and he has lent the house to somebody and he dies, his executors cannot take rent from the fellow. Neither can they evict them. In this case that went to the Supreme Court, Afrani versus Kweku, it took 14 years and the person was there as a statutory tenant. So these matters are there in our case law. And if there's an opportunity for us to do any amendment, the definition and scope of who a landlord is and the rights that will accrue to him deservedly have to be given proper attention. Secondly, and my final point, there are issues about the freedom of people to contract. I think there is one basic point that is absent in the Rent Act. There has to be a provision for implied covenants to be statutorily provided in the Rent Act. Now, these implied covenants will be covenants that will bring obligations upon the landlord and similar obligations upon the tenant. Now, there are some of these covenants that even gleaning from the case law, it has to necessarily be there. For example, the implied covenant of quiet enjoyment. There is a wide legal meaning to what quiet enjoyment means. The covenant for derogation from grant, there's a wide meaning that our case law has made pronouncements on. If you go to the part of the tenant, there is what they call the the covenant to keep the place in good and tenantable repair. So these variations that we are anticipating, the landlord wants this, the tenant wants that, and all that, these covenants have to be implied. So when you tie that in with the section 40, where we are talking about the standard covenant, the standard agreement being provided by the rent magistrate or the rent management board, that standard agreement would have the implied covenant, such that no one will have the right to construct a tenancy agreement outside those implied covenants.
Right.
These are some of the issues that I think have to be dealt with.
Thank you very much. That's a quick supply of information. If you look at the Rent Act 220, if you study it critically, and then the review in the literature is that the focus was more on the issue of rent and also recovery of possession, and not so much about the nuances of the structuring of the landlord-tenant relationship. And for that matter, that provision also has to be put in the context of the conveyancing decree, the implied covenant, now replaced by the Land Act. Yeah, so therefore, if in the new bill, if you want to do the proper thing so that the focus is no longer just on just the rent and the recovery of possession, but the whole of the relationship, the formation of the landlord relationship up to its very end. Then, as you rightly pointed out, then that should be it. Yeah, thank you. I think, all right, then we take the, we take him.
Okay, thank you very much.
Yes.
My point has to do with the side of the bill that suggested that landlords can only increase rent when there's an evidence of improvement. And during the analysis, I realized that our noble panelists, almost all of them said it's biased on the side of the landlords. But let's consider we the tenants or we the youth or some of us like we coming up. It's very obvious and evident enough that mostly landlords charge insane rents without considering any improvement. In most cases.
That's why that one, we want to wait. When you finish school and then you become a landlord, then we can.
So that is the point that if you are to consider that side, then there's a defeat on the proposed bill. Because looking at what the lawmaker is doing, he's trying to reduce the exploit on tenants and also, let me say, the public as a whole.
Right.
That is my suggestion.
Right. Thank you very much. I think we are going to take the next panel, but there's a lady over there, and LSU President, you still want to talk? Okay. Then you'll be the last one that we take the next panel.
Looking through the bill.
This is your name and then your
okay.
background.
I'm Gifty Agma Banina Akambase Adigun. Student. Reading through the bill, I'm an architect.
Right.
Reading through the bill, section 30, sub 3. I want a clarification on that. 30. That a person who sublets premises shall inform the landlord in writing within 14 days after the person has sublet the premises and the terms of the sublet. I don't understand it. I want a clarification.
Yeah. A person who sublet premises shall inform the landlord in writing within 14 days after that person has sublet the premises and the terms of the sublet. Okay, so subletting is the landlord has let the premises to you. And then you are going to give it to another person. You are not the landlord, but during the currency of the term. Let's say that you have it as, let's say, for 1 year, and you want to also sublet it for 6 months. Just example. Then the law is that when the provision, as quoted, that 14 days after giving it to another person, you are supposed to notify No, it's talking about like the provision. Okay, now let's go to the 32. Or even let's stay from 31, which is the general prohibition against subletting without consent of the landlord. So that is the general rule. If you want to sublet, you are supposed to get permission of the landlord. Good. Now, you get that permission, then the 2 is saying that the person in the case of tenancy of premise, other than the tenancy specified in subsection 1, of course, that is if it's not one which is shorter than 1 month, shall not sublet those premises in the absence of express agreement in writing to the contrary for a period in excess of the period of the tenancy. So if in the tenancy agreement you don't have a clause which, for example, forbid subletting, then so long as you are not having a tenancy of the indicated a shorter period, you can sublet, but you must have the permission of the landlord, as it were. And once you've done the subletting, you are supposed to update the landlord about the details of the subletting that you did. Because don't forget that the reversionary interest, so to speak, is still vested in the landlord. Okay, so yes, Dr. Ankunu. Yes. Good. And also there's this issue of privity of estate, privity of contract, but you don't want to go there now. Okay, so having said that, we'd like to give a big round of applause to our panelists. And while our panelists, they are rising so that we welcome the third panel, all of us, shall we stand up, please, so that we stretch? Thank you. All right, so, okay, panelists, please. Panelists, please come over for a photo opportunity. Second panel, please. Second panel, come for photo opportunity. Welcome back to the third round of panel discussion. And this will be the final round. Then we draw the curtain down on KNUST Faculty of Law in conjunction with Ministry of Works and Housing, Colloquium on Rent Bill 2022 and Ghana Housing Authority Bill. So I will introduce my panelists. To my extreme right, we have Professor Resford Asasi Opon, Department of Architecture, KNUST. Followed by Nana Ajakuma Difie II, Asante Mamponhima. To my immediate right, we have Professor Divine Ahaji, Head, Center for Settlement Studies, KNUST. To my immediate left, we have Dr. Chris Adomako Kwache, Head, Department of Commercial Law, KNUST. Followed by Mr. Mark Kakraba Ampe, Chief Executive Officer, Gold Street Real Estate Consort Limited. To my immediate left, we have Dr. Nicholas Adeboama, Department of Accounting and Finance, KNUST School of Business. Ladies and gentlemen, the panelists here will help us to discuss specific themes drawn from the Ghana Housing Bill 2022. Professor Asasi, having regard to the object and purpose of the bill, especially as reflected in the long title, do you consider it adequate?
Thank you very much. But before I go to answer your question, as a teacher, whenever you get a platform, you have to use it wisely. And at this point, the wisdom here is to provide some form of education for all of us. In fact, if you look at chapter 8 of our Constitution, it talks about the executive. And then it comes down to describe what the executive is. And the president, in fact, is actually referred to as the president. In fact, those of you who like counting, and I do, if you look at it, it is always said the president, the president, the president. So what it means is that when it comes to issues of national discussion, it doesn't matter who is there. I can become the president too. And whatever has to go for me, has to go for me. So the decisions that we take today is not only for a sitting president, but for the president of the Republic of Ghana. Now, coming back to the question, for purposes of exactness, I wrote the question and I answered myself. And the answer is yes. Yes, given the fact that I made that kind of connection in the morning that if you look at Ghana as a nation, this is the very first time that we are making effort to legislate, so to speak, housing, bringing it to the fore, because over the years, it's fragmental and also peripheral to a number of issues through policies and so forth and so forth. So a bill that seeks to promote or establish housing authority for the welfare, the safety, protection of the citizenry is something that is very important.
Yes.
So we need it.
Right, thank you. But there's one thing I want to pick on. If you look at the long title, And now to establish Ghana Housing Authority to operationalize the government housing policy. My trouble has to do with the government housing policy. Wouldn't it be better if it was something like the national housing policy, especially so since we legislate not for particular government, we legislate for the country, so that if you have like this particular act and tomorrow there's another government, it's still something which they should identify with. Yeah, so that is one drafting problem that I spotted with respect to how the title is formulated. But by looking at Mr. Ampem, I think that you want to say something on that before I move on.
Yeah, thank you. I think that maybe it's a mistake because the National Housing Policy 2015 actually makes provision for the establishment of a National Housing Authority. And this law that is being, the bill that is before us is intended to operationalize the National Housing Policy. And so I think that maybe there was an error in, interchanging national with government housing policy. That is how I saw it.
Right. Maybe I'll come back to Professor Asasi, but I may want to ask Professor Ahaji. Looking at the Ghana Housing Authority bill, do you think that it will have the desired effect and lead to the desired outcome? And this question is trying to find out whether from background reading that you have done, the sponsors of the bill, the ministry, and its collaborators, have they done the financial, economic, and social impact analysis of the bill, having regard to the unique nature of this interventionist legislation they are trying to make?
Okay, thank you very much. Yeah, if you go back to the 60s or thereabout, independence, Ghana was largely a rural country. And we had the ministry as we have it. At that time, in terms of the complexities around the housing issues, it was easy for the ministry to handle in that perspective, But down the lane 60 years, the dynamics have changed so much that now, in such urban economy, with so many complexities about housing is so complex that you cannot have the Ministry of Works and Housing as a directorate. Actually, the housing aspect is a directorate looking over, because we are in admission that we are in a housing crisis in this country, but yet we have a directorate sitting in Accra and trying to address the housing issue. And then, linking back to the rural, you realize that we used to have Department of Rural Housing, because the focus was then, as a rural, to address rural housing. Now, we all know that the city or urbanization is the pathway to development. That's why everybody is trooping to the urban areas. And we admit that the majority of the housing issues in terms of quantity is in the urban centers. But have you asked yourself whether we have a Department of Urban Housing? No. Recently, I attended a program where rural housing is now trying to change itself into Department of Urban Housing. It means they were trying to make themselves relevant. And the interesting thing is that, as I understand, it's under Ministry of Local Government. So it means that we have lost the link in terms of coordination and how to address something that we see as a critical issue. And coming to your question, I'm going to ask the question which I think we will all reflect on in terms of the policy direction. For instance, the Ministry of Works and Housing. If I ask now, what is the public policy on housing for the working class? Do we have it? What is the public policy for housing for the vulnerable and socially excluded? Do we have it? What is the public policy on housing for the informal workers? Do we have it? What is the public policy for housing for the people with disability? Do we have it? What is public policy for housing for the elderly? Do we have it? What is the public policy for housing for single mothers? Do we have it? So you see, we can go on. Go on. So you see that there's so much work for the ministry, but with the divided attention of trying to address housing, they are not even looking at other issues. And that is why the National Housing Authority is, one would even say, I made reference to where we started from as independent country, that is even long overdue, because we have allowed South Africa, Kenya, Egypt, Angola, and these countries to overtake us with National Housing Authority. And although we will say that this morning, I think somebody mentioned that when it comes to social interventions in Africa, they are all problematic. But certain countries are doing better than others. And it is a fact that these countries are doing better than Ghana.
Right. Thank you, Professor Ahaji. So I'll go to Professor Asasio before I come to Nadifie about issue of land. But let's take Professor Asasio on this same issue, if you have some thoughts to add to what Professor Ahaji has said.
Yes. The issue of having the Ghana National Housing Authority is actually long overdue. And as I said, that is why I'm particularly happy that this bill is really coming. But again, he touched on the issues from the perspective of specifics. But then, again, if you look at the issue of whether housing in this country has been stereotyped over the years, how do we deal with it? And you need such a body to be able to deal with that. The exclusion of the key players that he mentioned about, which is also linked to somehow the composition of the board within it, which I'm sure will come into it. Those who make the decision about housing, those who make the decision about these policies that we're talking about, do we really include the people who really matter? You know, the issue about rural housing is so key. And if you believe that about half of, we are not too sure of it, but we always say that Ghana is about 50% rural. So if it is 50% rural, then the housing policies that we have churned out over the years, do we really include the rural folks? Do we really do that? So it is long overdue, and for me, localizing this housing authority is key. Again, I don't think we have really conceptualized it well, because if you look at chapter 20 of the Constitution, the concept of the decentralization and the local governance system is basically deals with all these issues. And if you are to conceptualize it well, providing this housing for our people should not really be a problem. So having this authority is long overdue. Thank you.
Right, thank you, Prof. Now, land is needed for housing projects. All the various things we are going to talk about and contemplated in the law. The bottom line is that you cannot build in the air. Even if you are going to do skyscrapers, it must start from the ground before to project into the sky. And of course, lawyers will tell you that the air is also part of the land, so to speak. So, Nana Difie the second, how can our land ownership system respond to the need for release of land for rare estate development? Since you, Nananum, you have all the lands.
Thank you. First and foremost, you agree with me that there are two kind of way to lease land. One maybe to an individual or a real estate developer, or maybe to government by compulsory acquisition. My stake in this one is, as a traditional ruler, what am I going to get at the end of the day? Maybe for a good or better housing project for my folks. But when you look at it, I think the government should make compulsory acquisition in a way that is attractive for traditional rulers to like to invest. For instance, we gain our lands through conquest. I came from Ansiayase to my present day Mampo. For me, as a traditional ruler, it's by my birthright that I own land. So why will I give my land to government for compulsory acquisition? Which one? I might not get the right market price. 2, they might not pay me immediately. 3, it means when I give the land to government, I lose my inheritance forever. Then at the end of the day, prosperity is going to judge me. So I believe if government wants to acquire lands through the traditional leaders by compulsory acquisition, then there should be some sort of an arrangement or an agreement that it should have some timeline, that I don't lose my inheritance forever. So that at least from one generation to the generation, at least we still have something. I think the traditional rulers or the stool or the individual who owns lands that is being acquired by the state should have a say in it. There should be a timeline. As you're giving a lease to somebody else for 99 years, there should be a timeline for the state to revert back to the traditional authorities.
So Nana, will you, for example, embrace a provision in the law which says that if you are going to release a vast stretch of land for real estate development, maybe either a percentage of whatever compensation as we do the compulsory acquisition, or maybe the rent component, which the particular real estate company is going to be taken from the various tenants when the project is completed, should go to the relevant stool or traditional authority. Will you go for that?
Yes, I would do, because I believe that for compulsory acquisition, for me as a traditional ruler, if there's an agreement between me and government that I can put maybe 40% as equity or 60% as equity through rents and other stuff, I still maintain ownership of the place. And as a custodian of tradition and a custodian of my land, when I have interest in the property, let's assume it's a housing project, no matter what it is, my interest is in it, so I'll make sure the thing goes on and goes on well. Then we've seen other government projects which has been abandoned, and then there's no maintenance. But if I have interest in it, I'll make sure that even in my era now, I'll make sure the thing is done right. And for the future generation to also get something out of it. Not at the end of the day, government is going to pay me some small compensation and I lose everything forever.
Right, thank you, Nana. Now I'll come to Mr. Mark Kakraba Ampe. If you look at the Ghana Housing Authority Bill, certainly is seeking to create a new institution, the Ghana Housing Authority. Is this really necessary, or we think that this institution is already, what it's going to do is taken care of by some other existing institution?
Thank you, the moderator. And just a small bite on the point that Nana just made. And let me state that the issue of compulsory acquisition has been abused in this country unnecessarily. The law makes provision for compulsion when there is a land that is the only land available, and the owners, government thinks that without compulsion, the land cannot be made available. Other than that, the first approach to acquiring land for any purpose must be by private treaty. So you sit down, you negotiate, you agree, if it's for 99 years or for 50 years, because Nana is concerned about the right to continue to have recognition as the owner and for the land to benefit generations unborn. So if you extinguish the interest of the stool or the family, you have done that stool or family a disservice. And that is why the laws of this land are very slow in jumping to compulsion when it comes to acquiring land for government projects. Unfortunately, people who are put in place to manage these things are always in a hurry to adopt compulsory acquisition. And so if we are thinking about creating land banks, if we are thinking about making land available for housing development, we should look at what kind of arrangements would bring a win-win situation for the developer, for the expected tenants, and for the traditional authorities, so that together land matures in value over time. And the traditional owner must benefit from that improvement or enhancement in value going forward. That's my take on that. Now, coming to my
substantive
question. My answer will be yes and no. No in the sense that we don't currently have an entity that is doing what the law intends. But yes, in the sense that the history of our country attests to that. Now, in the Gold Coast era, we had the Gold Coast Housing Corporation. And then Kwame Nkrumah brought the State Housing Corporation. And the object, perhaps not in the entirety of the role the National Housing Authority that we seek to create was supposed to do, but they were doing aspects. And my thinking was that we could have done it incrementally to get here. And so I'm saying yes because the State Housing Corporation, which we have now converted into a company, a profit-making entity, must be reversed. I'm saying so also because if you create this National Housing Authority as a new establishment, you are now going to provide head office, regional office, district office, whatever, which comes with a huge cost. The resources that we need to bring about a lot of residential provision are now going to be locked in the provision of facilities which already exist with State Housing Corporation or State Housing Company. And so we could look at going back and using the existing structure of State Housing Company, revise that profit-making arrangement that it has now, because it's already in possession of state-acquired property when it wasn't a profit-making entity.
But before I leave you on that, if you look at the bill, what the Ghana Housing Authority is supposed to do, among other things, is to facilitate participation of the private sector in provision of affordable housing and all type of housing. And if you look at the State Housing Authority, I think its mandate is uniquely different.
I would not agree with you in that sense. What I mean is that, you see, we must evolve systems and structures. It's an evolutionary process. At a point in time, you deal with what is critical, and then going forward, other issues come up. And so, if State Housing Corporation had continued to provide social housing, which was the original intention, and now we think that they cannot do it alone, let us add some provisions to their mandate to be able to engage with private sector so we can get private sector on board. We enhance the law and the provisions and the mandates for them to achieve that. Now, the other issue about are they existing, I also looked at the National Housing Fund that is under the law, which already we have the National Housing and Mortgage Fund. And my question is, if you have the National Housing and Mortgage Fund 2019, and you are also establishing a National Housing Authority and giving it another mandate to establish a housing fund, what is the object? Are there no contradictions, or what is the differences between the housing fund that we're going to create? So I think that there are structures that exist which we can ride on to achieve what we seek to achieve under this law.
Right, so you want us to be guided by the principle of avoiding duplication, and also the principle of minimalism. Minimalism in the sense that you don't create institution where an existing institution can do what you want to do. You can give additional mandate, or you can refocus existing institution rather than creating a new one because of the attendant cost. All right. Now, because we've already opened up the issue of fund, I would like to, yes, and then I'm giving you a substantive, and then
you have a bite on that as well, because it's opening up the discussion on the National Housing Fund. If you look at the clause 26 to 30 of the bill, it envisages the establishment of a National Housing Fund, and because Mr. Kakraba has already started on that, I would like to find out whether you think that the objects or the purpose for which the fund is established are adequate, and as you rightly brought up, is it really necessary to have a national housing fund? So if you can be guided by all that, and also the source of fund, the income stream which is supposed to feed the fund. If you look at the clause 28, is the fund sustainable? Or we get to a stage where the fund will just be existing in name. There's no money in it for it to do what it's supposed to do. Yeah, so Dr. Buama, if you can address
Thank you very much.
This.
I think I will first give a bite on the issue raised by Nana, on the land issues. As Mr. Kakraba said, composing Akushi is not an option unless we are at a dead end. Now, what I think could be done is for the housing authority to facilitate engagement between developers and the landowners. They can facilitate the process, bring them together to negotiate on a win-win situation. So at the end of the day, the land will be released and the traditional authorities will also have a fair deal. But to acquire land into a land bank, I don't think it's an issue. And two, even if you are bringing them together to negotiate, then there may be no need for federal state investment in acquiring those lands, because the private sector will bring the capital. But the major issue is the willingness to release the land. So if they can engage them through the intervention of the authority, that will smoothen things out. Now, on the issue of the housing fund, I think the fund Mr. Kakra mentioned was proposed in the 2018 budget, and then set up in the Ministry of Finance. I suspect that is the fund we are talking about. And if you realize the amount government put into the fund, that was 40 million. And when I read the budget, I asked myself, are we serious?
You mean the National Housing Fund or the mortgage?
The National Housing Fund, the mortgage fund. Yeah.
Right.
It was something 40 million. And I asked myself, if you want to develop housing and you are starting 40 million cities, what is it? And what they did was that they provided assistance to some participating banks. So they lent the money in the fund to the banks at 2%. And then the banks provided a one-to-one matching fund and charged a market interest rate on the bank's fund. So when you calculate the weighted average cost of the WACC, then it comes about 12%. So the funds, the loans were given out at 12%, far below market rate. The question, how sustainable it is. And they had a 2-year pilot. I don't know whether we are still continuing with it, because I believe it wasn't sustainable, and the government has abandoned it. And the other issue was that there was no legislation on that. It was set up in the Ministry of Finance, catered for in the budget, so it could be abandoned at any point in time, either by the implementing government or whenever there's a change of government. So I feel that the innovation in the authorities bill is seeking to legislate on that. That will give it a mandate to ensure continuity of that. So that is not a bad idea. But looking at it carefully, the question is, how could we sustain this? If you look at the source of funding, you are talking about monies allocated by Parliament. So if Parliament is unable to allocate sufficient funds, then there will be no activities. We are talking about investments. Where would they even get the money to start the investment at all? So the bottom line is that state housing projects are leastly supported by the state itself. We don't provide sufficient funding for the project, and I don't think that we will have sufficient budgetary funding for the Ghana National Housing Fund. I don't think we will have it. I believe that the way to go is to use private sector funding to support housing development in this country. Naturally, housing is a long-term investment requiring a long-term funding. That means that we require investors with patience capital that can wait for 20, 30 years. So the only way we can do that is to look for investors with long-term liabilities. And thankfully, pension funds have long-term liabilities requiring long-dated assets to match their liabilities. So what is missing in this country is the disconnection between long-term sources of funds and the housing market. If you look at the pension funds in Ghana, the tier 2 funds, it's growing very, very fast. In 2019, we had about 26 billion assets under management. In 2018, 22 billion. In 2017, we had about 15 billion. And then in 2015, about 13 billion. So you realize that it's growing very, very fast. Let's look at the 2018 figure. Assuming we were able to channel even 10% of the pension funds in the housing market to the housing finance and development, that will be 2.2 billion. Compare that one with government budget allocation of 40 million. That is sufficiently inadequate. However, to be able to attract private funds, we need to provide the necessary incentives to make the system attractive to them. That is what is missing. Private pension funds could actually channel their funds to housing by not directly having exposure to the actual building. It could be done through the real estate investment trust. It could be done through mortgage funds, mortgage trust, where they acquire shares in these funds that have the expertise to develop and manage the properties. So they will get a cash flow out of that. Look at this. Tier 2 pension fund is supposed to be a kind of risky investment because the tier 1 is a very safe investment. But look at the composition of the investments over the last year, until 2019. Fixed deposits, 23%. Government bonds, 61%. Corporate bonds, 8%. Now, these are workers' contributions, and they need housing. Why invest in safe government bonds instead of risky housing projects that will guarantee them safe place to live and a safer future? So I believe the idea of the National Housing Fund won't work because we won't have sufficient funds. It won't be adequate. And even when we have the funds, state projects are highly inefficient. And we have a history of that in this country. We spend so much on the State Housing Corporation, and over 50 years, on average, they produce 415,000 units a year. That is an embarrassment. And I don't think it will be very different from this. And somebody will say that using private capital may make housing funds expensive. And I believe that there are several models around that could be used. And my brother Zinzi touched on one of them, using the planning system. Because it is the responsibility of the planning authority, which is the district assembly. I think Professor also touched on that. This is to give what? Planning permit. So in the permitting process, they can negotiate that a certain percentage of the housing to be developed should be for a certain class of what? People, the target market. In that process, the state can also come in and provide them tax exemptions on the 5% or 10 or 2% housing units that goes into affordable or to the low-income households. With that, there will be a win-win deal, and we will be able to channel private funds to support both high-income and low-income housing development without any stress on the national budget. Thank you.
Yeah. So, Doc, you argued that we should take the National Housing Fund instead of, for example, modifying to enable the other sources of funding, like aspect of the pension funds and all that, to be able to invest in the housing sector. Because if you look at clause 28, the possibility of taking care of some of these sources are there.
Thank you very much. I think that the National Housing Authority should be a regulator. That should regulate the housing market. But shouldn't be a direct participant in housing delivery. They won't be able to do it. It won't be successful. We have a history in this country. At the end of the day, the target beneficiaries end up as tenants in the same properties.
No, I'm talking about the fund.
But yeah, so how will this fund be managed? Possibly they will identify some banks. Possibly they will identify some projects. Because if you read it, say, facilitate housing development to a certain target or certain segment of the market. How would it be done? Either they go to direct development or they channel these funds to developers. At what cost? But this could easily be done without any stress on our budget through private funds with work-structured incentives. So I don't really support that idea. I think we can do away with that.
Thank you, Dr. Boma. Dr. Domako Kwache, because of your interest in public funds, what is your take on the proposed National Housing Fund?
Yeah, thank you very much, Mr. Moderator. I think my brother has already raised some of the issues. But I want to bring to the fore practice that exists, at least in England and then in South Africa, where, like he said, the housing authorities are only regulators. They only regulate what the individual contractors are able to do. For example, in 2017, when I went to South Africa, I registered as a student in February. And then I saw an area being demarcated. Then they wrote the campus ride student accommodation. I mean, it took less than 1 year, and the whole building was completed with students in paying. Because you see, putting up houses, if you delay, you have cost overrun. And that also contributes to the financial structure that we have in Ghana. Government always wants to spearhead, but I think it is something that should be left with private developers so that they would come in with money. Then what the government would then do is to give them incentives. Because if you're looking at the rate at which individual houses are put up, at least by these estate agents, the prices are very high because they don't get any support. They would have to go to the bank and then take money. But then, for example, if you look at UK, they have what they refer to as the blended approach. So the local authority plays a role. The government also plays a role. They even have set up a fund that if you want to develop for this particular target group, you would be able to access from that particular fund. The fund are operated by independent body. You put it up. And then I also want to look at what Nana said with respect to funding. I see no reason why we should set up a body to buy land or compulsorily acquire land. We must explore innovative ways of bringing an animal on board. So you may be looking at, and she mentioned it, equity. This property that we are going to put up, one, the traditional ruler or whoever releases land to be quantified. Then it will be factored into the project. So, for example, Nananum would have a particular project, you have about 5 to 10% equity in it. Once we have those structures, the government will be released so that the private participants sure that, for example, we want to look at this low-cost housing. We have people in the middle. Then we also have those who are at the upper echelons who are able to afford. I think looking at it that way, it will be beneficial in getting more houses than the current state in which we have. For example, if they are talking about investment. Investment, where are you going to invest it? This era where inflation is so high, or you are sending it out, interest rates there are not anything to write home about. So you are also talking about loans. So you go and borrow and then go and invest it. So that scheme provided for under Section needs everything. And I would recommend, just as my brother did that, let us make sure that we engage the private sector. And again, when you look at the board, I think we will come there. It is heavily tilted the direction of government. It's government controlled. So if I'm a private person and then I see this bill, I would never put any investment in it. So the board must also be looked at again, where you open up, bring other interest holders on board, sure that together they will be able to front load the financing for houses in Ghana.
Right, thank you. Professor Haji, do we really need Ghana Housing Authority to serve as a catalyst for massive expansion in real estate housing development?
Yeah, thank you very much. I think I will give you a scenario. A couple of months ago, we invited one social housing developer from South Africa to Ghana for a conference. And you see, that is, Ghana, we don't want to admit that we haven't developed our system. We have a social housing developer in South Africa. They focus on social housing. So when you talk about private developers, I wonder what, we don't want to move with the tempo. Now, this social housing developer took the municipal to court. Please listen to this carefully. Because he was developing a land for the people, a house for the people, which is a right, and the government was thwarting its efforts. It took the issue to court, and it won. Why did it win? Because of the issue you are discussing, that housing is a right. So when it is observed that the municipality was rather the one putting obstacles on the way of the developer, they won the case. Will this happen in Ghana? It won't happen. You see, so we don't want to, so just as you said now, why are we doing National Housing Authority? It's because we are confronted with a housing problem, which we have all agreed that is the government's responsibility. Look at what Malaysia have in their housing authority. It's specifically written that the National Housing Authority has the mandate for the lowest 30%. Specific. So the issue is, once you take that decision that is for the lowest 30%, it's not the private sector who will build that house for you. It is the government that has to design a scheme by bringing on board either social housing developers or, as they have in the UK, housing associations. And that is why you mentioned the fund. Then there's a fund set for them. So that is where, for instance, your suggestion, State Housing Corporation, I agree with you, should go back. But they cannot be the regulator. State Housing Authority will be the regulator. But State Housing Corporation will now be building such that they will focus on non-for-profit housing. Then, as State for Housing Corporation is doing that, the government is now giving incentive to private sector to help. And one example is, for instance, in the UK, we have build now and pay later. So government gives the land to the property developer. They say, develop it for affordable housing for this particular group of people. If you're able to develop it, sell about 80% beyond the market price, and I take the rest. You see, that is where government comes in, because you know the people you want to target. So, as far as where we are now, we need the authority to regulate the system, focusing on those who are needy. And it will be the purpose of the regulator to be able to identify those who are needy. For instance, well, maybe you take out the students. Many of us here will not want to rely on the government for any support to build houses or our house. So why should the government be thinking about, unless you fall into a vulnerable situation? You see, but what we have currently is that all our attempts at looking at those who are vulnerable ends up with those at the top. I've just come from a state housing project in Boteman, where somebody has bought the whole property and converted it to apartments and is giving it out to holiday makers. You see, but if you have the authority in place, for instance, if you acquire such a building, there will be a regulation where you cannot rent it beyond a certain value. So actually, we don't even have eligibility criteria for affordable housing in this country. We build it, and for instance, if you own a house already in a particular area, why do you have to be able to acquire such a house? But in serious countries where they have eligibility criteria. If you own a house already in that area, you are not part of it. You see, we don't have all these things. Our industry is just open with no direction in it. And that is why I think the authority is needed critically to be able to help so that the ministry can focus on the policy aspect, and then they will do the regulator, and then now they will bring on board State Housing Corporation. It goes back, focus on low-cost housing. Then government now begin to entice the private sector with other schemes to also help. Even in Germany and co, churches and all these other philanthropists contribute to the fund, you know. And then, so that is why I think that the mortgage thing, fine, but that one, I think, unless you say it's a fund and also a mortgage, but I'm seeing it as is to help those who want to acquire, you see. But, you know, this morning the minister mentioned subsidy. Do you know the implication of subsidy? Government is saying that it's going to subsidize for people who cannot access the housing ladder. And government will sit down for you to build expensive house so that he'll come and subsidize. No. So it is the responsibility of the government to make sure that the building that comes onto the market is as moderate as possible so that when it is subsidizing, it will be at low cost. And how do you do that? You need the housing authority in place to be able to handle that. Thank you very much.
Thank you, Professor Haji. Yes, Dr. Boama, you can have a bite.
Thank
then
you
I go
very
to Professor Sase. The Professor Sase, when he finishes, I'd like you to address the adequacy of the composition of the governing board of the Ghana Housing Authority. Because in principle, consensus seems to be emerging that the authority is necessary. It's just a question of its mandate that should play the role of a regulator, and then they being, if you like, the create the enabling environment rather than being a provider. All right.
I think Prof just mentioned that the mortgage thing may not help the low-income people. In fact, when we talk about affordability for whom? What income, what price tag? What income bracket? And that is what he was arguing, that we need to be very clear as to who qualifies, who is eligible. But we can still have a well-functioning mortgage market with market-determined interest rate and sales provide affordable housing finance to the poor. What we have to do is that, let's assume that our focus is on those with a median income of, say, 20,000. Then the principle could be that you can borrow at the market rate, but the government will provide you interest subsidy through tax deduction. So at the end of the day, you are supposed to pay your income tax, but a percentage of that is given back to you as a subsidy on the loans you have taken as a low-income person, and that will work perfectly.
Right, thank you. Yes, Professor Sase.
Okay, thank you very much, Dean Esquire. I think it's established that the establishment of this Ghana Housing Authority is long overdue. I see the object of it in twofold. One is to serve as a regulator, and one is to be a provider from the constitutional perspective if we are to go into social housing. Because nobody, apart from government, can do the social housing bit. So I think that has to be clear. In trying to really appreciate the composition, because sometimes comments of this nature, you do it with a high sense of trepidation, looking at where we stand.
No, Prof, this is not law yet. So we are trying to make the law. And just before you move on, when the other student made the contribution, I said that you should wait until
he becomes
a landlord.
Yeah.
I wanted to say that if you look at this Ross and the Nozick approach to justice, what they call like the blind perspective. Yeah. So let us assume that we don't know where we'll be. Whether you're going to be the landlord, you're going to be the tenant.
Yeah.
And we're trying to make the best law possible so that when I am contributing, I'm not thinking of my interest as
Exactly.
being owner of 2 or 3 or 4 houses or being a tenant,
Yes.
but just the best system so that wherever I happen to find myself, whether as a tenant or whether as a landlord, then there's no problem. So the same thing applies to composition of this governing board.
Yes.
But not maybe because I'm a lawyer or I'm an architect or I am this. Yes.
Yes, exactly that is the point. So we all know that we want to make the best for the best and out of the best. I mean, that is the essence of this exercise. I tried to look at a lot of jurisdictions and realized that if you look at countries that have actually, evolved and having their housing policies or strategies working, it is all by the operations of housing authorities. I looked at state of Colombia, I looked at Virginia, even went to Sudan and Kenya, and then realized that it is all about the state housing authority. But what I realized was that the composition of it is more geared towards a business-oriented approach. So the appointment of the chief executive of the authority is actually advertised. And they have given what you're supposed to do within a specified term to do A, B, C, D. So you come in as a business person with your vision. And therefore, if you are not able to deliver, you are sacked. Now, if you look at ours, the whole thing is enshrined in the Constitution. And that is actually more or less overburdening the president. Because the appointment is hinged on Article 70, as well as Article 195 of the Constitution. And in fact, if you look at even the processes of the president appointing these people to be on the board, what I was thinking is that the possibility that a board will be in place 2-3 years is over, because the president has to come, he has to get his nomination on the advice of the Council of State. And we all know how Council of State, operates, how he's also appointed and all that. So before this is constituted, then the time is really elapsed. Now, if you come into the details of it, we have a representation from Ministry of Works and Housing, Ministry of Local Government, Ministry of Rural Development, Ministry of Land, nominated by the minister. All these people are nominated by the respective, ministers of the. Then you come to D, which is the representation from the various professional bodies. Now, E talks about 3 other persons nominated by the president, at least one of whom should be a woman. Now you are likely to be on it one day. Now, the issue is that this is a body that is supposed to more or less regulate, a body to provide social housing. And the Constitution is overly, by political appointees. Now, what makes it even worse is that if you go to the policy directives, which is 12, it talks about the minister may give directives to the board on matters of policy, and the board shall comply. From grammar point of view, what does it really mean for the board? Where a minister may, that is very discretionary, isn't it? But if a minister gives a discretionary directive the board shall comply. Good or bad, we have to do it. So I think that we need to look at the Constitution. Of course, that's why I said that if you look at some jurisdictions, the way they operate is actually is akin to the Chapter 20, the decentralization and the local government system, whereby they even have the formation of the committees within this are not committees that are to more or less serve as a check, but they are committees within the board to still work. But in some jurisdictions, they have what they call Citizens Review Committee. And what the Citizens Review Committee does is that what it does is that they look at what the authority is supposed to do over a period of time. And if they are not doing it, they have every right to take the authority to court, because according to the law, it can sue and be sued. So I think going forward, we need to look at the composition.
Right.
Thank you very much.
Thank you, Prof. Before I come to the panelists for your closing remarks, Dr. Adomako Kwache, clause 36 of the bill anticipates the making of regulation by means of legislative instrument by the minister to provide specification for national housing programs and standardization of house types for housing markets. I want to find out from you and Mr. Kakraba Ampem as to whether this is a good innovation, or we should rather give real estate developers the room to exercise creativity.
Yeah, thank you very much. I think that asking the minister to get involved in this through LI is not going to be helpful. Because if you look at the duties spelled out under that, it's something that should be within the domain of stakeholders, particularly estate agents, contractors who are going to be on the project. And like what Prof. earlier raised, these are some of the issues that should be ironed out carefully in order not to bring friction and conflict between the board and the authority itself. Because for me, what they have indicated in clause 36, that should be a duty under LI, and it's not going to help. That should be left to the stakeholders in that particular
area. Right, thank you. Mr. Akraba Ampem.
Yeah, but I think that the LI would be facilitated by the Ministry of Works and Housing. That is why the minister is there. I mean, using the minister, it's actually reference to the ministry. And because they are the ones bringing this law into existence, and they have to also work on the LI that will operationalize the law. And so using the minister, I think, is appropriate. Except that, yes, the engagements must be so wide, bring on board as many as stakeholders in the space to ensure that whatever rules, because it's the LI itself that is going to give flesh to the law. And so as many stakeholders as possible must be engaged to ensure that the ultimate rules that are outlined there would fit the purpose.
Right, thank you. But because we have, yes, Dr. Boama, yes.
Hello, thank you. I was asking myself whether we even need this LI, just as you asked. Because if you look at it, we have National Housing Regulation. LI is the 196.
National Building Regulation.
National Building Regulation. That sets building standards. We also have the building code that was passed recently. So why they need
special planning?
Yeah. So why they need for another LI to operationalize this? We have enough laws in existence that should be able to deal with this. I think so.
Maybe the housing types is where you may think that the LI is not necessary because of the special planning, town and country planning, the national building regulations. But there are some operational details apart from the housing types, which will still need to be fleshed out in an LI. So maybe that one, it can be maintained.
Yeah, that is true, precisely. But the issue is, so if we have contradictory allies, if we have alternative allies,
yes,
and the provisions are so contradictory, where do we stand? So we need to align this with the existing allies. If there are gaps, then the gaps could be filled. There's no need for another ally.
Right.
Mr. Moderator, I think you, in one of the submissions, you made a point that for me, this National Housing Authority is more or less an icing on the cake. We have the laws in quote, or the policies or the legislative instruments. Even the LI 1630 had been, I think, changed recently. And then we have the National Regulation, whatever, the Special Planning Act, and all these things are there. So is it possible to have this kind of overlays, okay, and just bring it under this act for it to work so that we don't have a duplication? Our problem in this country is that we have too many policies and rules, but at the end of the day, they are all doing the same thing. It's like paracetamol, different types, but they all cure headache. Thank you.
Okay, so having said that, I am going to invite panelists to tell us what they think should have been added to the bill, which is not there. Or your closing advice to the ministry, which is a sponsor of this particular law. So Nana, please.
Well, what I can say is the Ghana Housing Authority should be a regulator between the private developer and the traditional authorities or the stool in which they want to acquire the land from, so that they can negotiate. When you go to places like England, they are very expensive places, but the same expensive place, you find very affordable housing within it. So what the Ministry of Housing can also do is, or the government can do, is also to give incentives for developers as like a tax rebate or something, and they can get some small percentage in which, even if it's a very posh area or a very expensive area, you'll still have affordable housing for people as well.
Right, thank you, Nana. Yeah, so I'll go to Mr. Kakraba, and then I'll take the rest.
Okay, thank you. Just a quick one on the LI. What I think, I mean, you can't have a law and it has no LI that operationalizes it. So what you do is that if there are other laws that relate to some of the subject matters of that law, you make reference to them, so that when it comes to housing standards, this law, this LI in relation to housing standards will operate. I think we have to look at it from that angle, and not to say that because those ones exist, because there are other things in this law that may not have any existing LI that can operationalize them. So by way of my closing comments, I'll go back to what we are seeking to do: providing housing, decent housing for all. Now, the challenge with housing in this country has two main factors. The first one being the supply side, which ordinarily relates to the costs, which relates to access to land and other matters. And the second one is income levels. If we cannot do anything about income levels, all the things we are discussing will be in vain. Because income levels are woefully low. Most of the people's incomes cannot support decent accommodation. So if government wants to do social housing, and we are not looking at incomes, living wages, it is something that as a country we need to take critical look at. Because we have university graduates who earn less than 2,000 cedis a month. And if you have to spend about at most 30% of your income on accommodation, if my income is 2,000, then it means I have only 600 cedis to spend on rent. And if I have a family of 5, 2-bedroom accommodation in a decent place will go over and above 600. So whilst we are trying to look at how we have interventions that ensures that our citizens have decent accommodation because housing is a right, we need to also look at the income levels as a country. It's a chicken and egg kind of puzzle, whether we should step up the income of the people and get them to work more, or they should work very hard so we can adequately remunerate them. But we need to also look at that, because if we don't match the two, it's a demand and supply thing. Even if you have so much in the market and the people's incomes are low, as we speak now, if you drive through in Shiaeso, Atasomanso, Adebeba, if you go to East Legon Airport, you will see vacant accommodation, a lot of them. Why? Because the markets for which those ones have been built, the income levels of the majority of the people cannot match. So there are people looking for accommodation, there are accommodation available, they cannot afford. Until we do something seriously about income levels in this country, we will still have this housing challenge hanging around our necks. Thank you.
Thank you very much. Yeah, Dr. Domako Kwache.
Thank you very much, moderator. For purposes of my closing remarks, I want the sponsors of the bill to take a critical look at two issues. The first is about appointment. I mean, the issue of the president appointing the person, and then the other staff, I think there should be a second look at it. And I will recommend that, like Professor Asase suggested, Public Services Commission should be allowed for the application to be made. Then it goes through them, the individuals appear before them, they interview them, and then whoever has the qualification cut out for the job will be given that particular job. And then secondly, I also want a situation where the appointment will be tenured. I mean, in Ghana, we have this change of government, and the moment a new government comes, it's wholesale replacement. Everybody goes. So that if we are appointing somebody, they should give, you are here for 4 years, 6 years, 5 years, whether renewable or not renewable, and then again based upon performance. Because we have a situation where the public services now, somebody takes home so much, but at the end of the year, that entity he or she is heading is making a loss. I mean, that won't happen in any business setting. But I think that is what we should look at with respect to appointment.
Right. Thank you. Dr. Debwama, closing thoughts. I think what I want to say is that one is on the governing board. As I look at it, I ask myself, you are talking about housing, you are talking about land, and there is no surveyor on the board. There is no surveyor on the board. And then there is no interest groups on the board. And yeah, they are there, but there is no surveyor. I have seen the architects there, I have seen planners there, there is no surveyor there. And when it comes to land, Ghana Institute of Survey are not there. When it comes to land and housing, you can't do without them. They have the expertise to help in those things. And then we don't have interest groups. As the traditional authorities, they are not there. Prof. Eji mentioned a lot of interest groups. The vulnerable, they are not there. I mean, there should be representation from people who are focused on social housing provision. All these things are missing. And to why land banks, I don't think it's a good idea. If you facilitate a negotiation between the landowners, then none can use their bargaining power to even bargain for social housing to be part of any project in their area to support their people. Thank you.
Right, thank you. So we take Professor Asase upon I come to Professor Haji, and then we come to the audience. We have the closing remarks by the chairperson. Then the chaplain is already there. We have the closing prayer.
Thank you very much. I have 3 points. The first one is about looking for overlays. And then, as we've agreed, where there's a need to take out, we take out and have a common ally. I support that. And I still want to also bring it to the attention of the ministry, looking at the amalgamation of the rent bill and also the this housing authority bill. I still feel strongly that it should be looked at. And my last point, which is dear to my heart, is about the governing board, which again I want to give a very classical example, whereby in one jurisdiction, in fact, as I said, if you look at it critically.
Prof, sorry to take you on. Your suggestion that you should merge the rent bill and the Ghana Housing Authority bill. Can you give one or two straightforward reasons?
Yeah, because I believe that from the discussions that we had, if you want to regulate rent and you are not providing housing for the people, as a nation, you are not providing the housing, but you want to regulate the private individual who is doing his best to provide it. I find it a bit problematic.
Right. Okay.
That's where I'm coming from. Right. So it has to be looked at. But, moderator, you see, we can get this governing body to be independent. And as I indicated, there are a number of case studies around the world. They actually call them Board of Commissioners, for example. And the Board of Commissioners is appointed by, let's say, a municipal chief executive, because they've localized the housing issues. So they know that for this settlement of 3,000 people, 3 million people, this is the houses that they need. So they constitute this board to really make sure that the housing needs are solved. And the people who are appointed onto this committee are independent. In fact, it says that a commissioner cannot hold public office in the municipality while he or she serves his term as a commissioner. So you can see the independence here. You know, but here you have the same person being the player, the referee, the landsman, the touchline doctor, and everything. So at the end of the day, nothing gets done. So I still want to really recommend that the constitution of the governing body should be looked at critically. Thank you very much.
Thank you, Professor Sasio. So let's take Professor Ayaji. Then we come to audience.
Thank you very much. Yeah, I think I'll also add my voice to the composition of the board. And I think I had a chance to be at the first breakfast meeting the minister had, I think, Real Estate Times in Accra. And I recall that one of the things that he said about bringing the National Housing Authority was the fact that there was not only too much political interference in the housing issues when government changes hands. And so if the National Authority is there, it means it's going to be independent. So it means that from what we are seeing now, then we are even going to back to square one. Because at the end of the day, if all of them are appointed by the president, then the status quo is going to continue. Then the issue will come up now, because already there are people asking questions. We are setting up too many authorities in this country, and they are not working. You see, we all see the relevance, but we go through the status quo, and then it becomes the same thing again. So I think that's the first thing. The other thing that I think we discussed it last night, where I've also done a lot of reading around this National Housing Authority, and I always come across Housing Act. You know, maybe the lawyers will be the people that you need to have a Housing Act even before, because what act is giving the mandates to the National Housing Authority? But I haven't heard so far so that's why I'm saying maybe it is the lawyers who can. Because, for instance, when it comes to even the housing, I have here single-family houses, apartments, high-rise, skyscrapers, condominium, temporary structures. How is the law regulating all this in the space? So this issue of the act is something that we need to, Housing Act, that is where maybe the rent issue could all come under as you are saying. And then to end where my good friend Mr. Kakraba, he talked about the income, which is low and very, very critical. So I have this triple action here of job creation and income, increasing the housing supply, which we all admit that the government has not done enough. And then if the mortgage facility is there. But the last one is on something, job housing balance, which we have not taken care of or taken notice in this country. You see, we often deliver the houses, forgetting that houses should go with job creation. So we have houses actually, and people are living far from their workplace. So I was even thinking, when this one district, one factory started, the first question I asked myself, what was the element of housing in the factory? Because when it comes to infrastructure and housing, they should go hand in hand. You cannot, if you go and build a factory somewhere and you don't have houses around, people come and create slums, because the people who have to service the factory will have to come from a home. And everybody wants to commute closer to the workplace. So it is something that I think the ministry should be looking at, the job housing balance, which might mean that perhaps we are putting up houses in areas which do not actually need it because they don't even have the jobs there. And then you stay 5 hours in traffic, going in and out, and it affects productivity and everything. So I think that is where I will end on this note. Thank you very much.
Thank you. Shall we give a round of applause to our panelists? No, you're the first. Yeah. Yeah, so we will take a few contributions because of time. And please, we'd like you to be straightforward to the point. Don't take more than 1 minute. Thank you. Dr. Sondem.
Because I've looked at the objects of the authority and I've looked at the functions. If we were to replace the name with Ghana Housing Service instead of Ghana Housing Authority, will there be significant differences or implications?
Yes, constitutionally there will be, because housing is a broader constitutional, service is a broader constitutional concept. That's why we have like the health service, we have the education service, and so on. So that will give rise to the fear all of us have, this duplication and multiplicity of institution. But once you have like the service, the next thing will be creating departments, divisions, directorates, and so on. So that may be the only challenge conceptually. Otherwise, then this.
I think I'll go on the same line of explanation. But again, perhaps the question, can I call you my learned friend because I want to be your friend? Yeah. The issue is having a housing act. I think that will really help in this whole issue, because we have Education Act, the Energy Act, the Special Act, this act. Because as we had a small discussion on our group, I was asking I'd engage a relative who is a legal person that an act, an authority which is bigger, having Ghana Housing Authority and having Ghana Housing Act, which is bigger. And I think the explanation is that the authority, or?
No, not necessarily. It's a question of nomenclature and legal taxonomy. Exactly. It's the content rather than the label.
Calm down. What do you mean by that? Yeah. So it is not an issue of the name. After all, what is in the name? Yeah. The concept is that I believe that what we need to really provide housing for us is under Chapter 20 of our Constitution. It is there. I strongly believe that it is there. And if we operationalize it well, we won't have a problem, because the decentralization concept will help us solve a lot of problems. Because housing is local. Now you're going to have this body sitting in Accra. The person who is leading this body may not know what is happening at Tuobodom or a village in Tuobodom. But if it is localized and the people are working to it, then I'm sure we'll be solving a problem.
Yeah.
So it is not about the name, but getting the job done.
Yes.
Thank
I
you.
wouldn't have said this, but I did some UNICEF work for Ministry of Gender, Children and Social Protection on what called the Social Protection Bill the last 2-3 years. And because of what we said, there's a concept, the local government comes in, and Professor Heji also is talking about jobs and then jobs, housing, yeah. So what is happening is that, so in the Social Protection Bill, for example, we had like a similar, what we call the cross-cutting issues. So there's a provision of what we call the interministerial consultative or somebody. Because like, if you look at this, Ministry of Works and Housing is implicated, local governance, lands and natural resources, and then the rural development, then the employment, labor, isn't it? Yeah, and then so even trade, one district, one factory. So if we are going to have like a grand legislative framework to govern housing and provision of housing, I think that having interministerial body, which will be headed by the president or person appointed by the president, because the ministers are equal, in order to ensure seriousness and cooperation, I think it will be something worth looking into. Yes. Yes, please. Any other?
I wanted to make a short comment. Looking through section 1, subsection 1 through 3, I do not see the entity as a legal entity which can sue and be sued. I don't know whether there have been a comment on that. Because it looks like free zone. You can't sue it. It can enter into a contract with you under section 1, subsection 2. You can enter a contract with you, can sell property to you, but you cannot sue it. So if they want it to be in the market, then they have to add that it has the power to sue and be sued. Then you have clothed it with legal capacity. Other than that, as it is now, you can't sue it and it cannot also sue you. Then whom do you sue?
Right.
Then lastly, talking about the compulsory acquisition, it looks like the government is always interested in making the poor poorer through acquisition. You see, free zone lands here, 1,099 acres, they were acquired in 2005. As of today, nothing has been done about it. We did a private work on it, and about 600 people have built on it. And then somebody, I don't want to mention him, somebody said, at the appropriate time, we will demolish all of them. 600 houses. And these are the people whose relatives are somewhere and have raised money. And people are living there. You are going to destroy them. As of 2001, compulsory acquisition payment outstanding was over 1 trillion in this country. This 2020 Land Act did not make any provision for the payment of it. And now the new act says when there is a hindrance, the government can acquire. Are we not tired of compulsory acquisitions? There are so many problems, abuses, and then the vulnerable are the people who are affected. So I think that if they now want to enter into the market, we are all going to the market. Let this authority enter the market, buy the land and build to help the poor, rather than acquiring lands belonging to the poor, walking them away from the land to make them armed robbers.
All right, thank you. Mr. Kodia, yes, I think, yes, Mr. Frane and then Mr. Owari.
Thank you very much. I would want to, in the first place, say that, left to me alone, this housing authority bill is a non-starter. We should not waste our time as a country on this. We have so many existing institutions which are more or less doing the same thing. Lands Commission, as it stands now, we have Public and Invested Land Department, Valuation Department, and Administrator of Two Lands is even supposed to be part of it, which is not part yet. The lab project 1, 2, 3, we don't see the true effect of what they are doing on the ground. The Lands Act, the new Lands Act, was supposed to help build what we call customary land secretariats within all the traditional settings. We haven't been able to implement this. This is coming from Ministry of Housing, and Ministry of Housing is having a defunct department, Public Works institution, sitting there. We don't know what they are doing. Please. Yes. At the moment, if you really look at the objectives or the functions that this authority is going to create, the Lands Commission is already creating, doing the same. And even if you go into the effect, the rare effects of what we have done before, the compulsory acquisitions that we took and built government bungalows on, practically now we are giving it to private people to develop because the government bungalows are more or less not effectively used. Let's go to Rage, the Nyame area right now and see the springing up developments. They are all for private people. Why? Because if you really go into it, these are prime lands, first class areas. Government workers are living in these buildings, paying rent as low as 100 cedis a month. While a private man will come and build on that same piece of land and renting it out at $2,500 a month. Please, let's talk about even ownership. As Nana was talking about the fact that the lands in the first place don't belong to government. Yes. Okay. So all that I want to say is that this is just another waste of time, another brofo that we want to just create another, excuse my language, caricature around, which is not coming to serve any purpose. Let us, as a matter of urgency, make sure that the institutions, the existing institutions are working. That is what Ghana needs. We don't have to go for another budget to finance a whole other albatross on our neck again. Thank you.
Okay. Yes, Mr. Kakraba will come in, but let's be temperate and measured in our contribution, because mind you, here is an academic institution. We are not politicians. We are academics. And you look at the broad spectrum of experts. So here, when we are speaking from research and expert perspective, not from political perspective. So when you're also contributing, be guided by such the intellectual community in which we are. But when we go to the other side, then we can box the politicians. Yeah.
Yeah, thank you. I appreciate his frustration, but that is not enough to draw the conclusion that he came to, that we are wasting our time. What it is that as a country, we haven't had a framework that addresses housing issues, and that is what the Ministry of Works and Housing is trying to do at this stage. The fact that other entities have failed in their mandates does not necessarily mean that if there's a need for another setup to address an issue, we couldn't do that. And so, yes, we have seen more of those, but it doesn't stop us from attempting others. And let me also add to this land and job thing that when I looked at the Sagleme investment, I was sharing with somebody that perhaps government should consider putting up a university in that area.
Where?
Sagleme, where we have this housing estates, people cannot, because commuting from that place to Tema and Accra on daily basis, the poor that you anticipate to be living there is going to be worse off. So it will be prudent for us to put a work entity, and a university can better fit that environment, and that comes with a whole economy, and then those buildings can be used. And so going forward, when we are looking at social housing, we must be conscious about even the location, because if I cannot afford 200 cedis rent at Asafo, and you go and put me at Anrian Kwanta, and you are subsidizing my rent, and every day I have to move from Anrian Kwanta to KJTR to come and ply my trade, you haven't helped me. And so the law must look at all these things, and I think that we will need a lot of time on this bill to shape it in such a way that it will serve our purpose. Thank you.
Right, thank you very much. Yes, Rose, we'll hand over
Thank
to
you. Thank you very much, Doc. I have some contribution to make as far as clause 32 is concerned. It talks about confidentiality, and the effect of it is that the members of the board, including the chief executive officer or the employer of the authority, shall not have the right to say anything or disclose any information that they come into contact with in the course of their duty. And I find that too far fetching. And the reason is that I had the opportunity to look at some other common law countries, what they do there. Specifically, I consider the UK. They have a similar entity like what we are seeking to establish. That is the regulation of social housing. And they are also regulated by a board. And the transparency that governs them, I believe, is why, or is what has contributed to their success. The transparency is such that even before they assume office, they have to disclose their likely conflict of interest. And this disclosure is published on the website of the regulator of social housing to make it accessible to everyone who wishes to know. When you come here, we have a similar provision in the bill, but with that, it is stated that when they disclose it or before they assume office, they should state it and file it with the board. And if you look at the provisions that follow subsequently, should they fail to do it, they are only charged 100 penalty units, which our prosecutor made us know that it's just 1,200, which means it is not deterrent enough. So what I would want to propose is that the provisions under clause 9.2 can be included. And the effect of that is that if any member of the board fails to do so, the minister, in writing to the president, may terminate his appointment. I think that would be deterrent enough and also improve transparency, which would, at the end of the day, help the board in its function to be a success. So coming back to the confidentiality, and also what I noticed is that the board, even after the end of their meetings, the minute is published on the website for everybody to know what was discussed. Because at the end of the day, they are seeking to serve the interest of the citizen. And this authority is going to be funded by funds from the consolidated fund, and budgetary allocations to will be made. So what is confidential about using state money to meet our needs? Why should they be gagged? I see this provision as a gagging provision just to make them keep quiet. Because with my background as a construction lawyer, a lot of money goes into construction projects, like the housing project that the board is seeking to work closely with. So, in order to avoid corruption and certain shady deals, I think that this provision should be looked at. If there's any information they are not supposed to disclose, then that information should affect national security. If it is not anything that will go against the national security, I think that the members on the board who may come into contact with certain information which they think the public ought to know about it, they should not be gagged. Yes.
Right.
Thank you.
Thank you, Rose. And before we leave, let me say that this is not the end of the views that we are eliciting. And we have our team of rapporteur. So our lead rapporteur, Dr. Inkum Menu Tadios, is here. So let's see you. Okay. Then we have Mame Efria Adaze, the back. Mrs. Delala Gau. So they are helping us to. What did I say? Oh, right. I think. All right. Thank you. Yeah. So they are helping us to document all the suggestions and comments, critiques which are coming, so that later stage we will share them with the ministry through the chief director. So having said that, we are going to yield the platform to the MC and the chairperson. But I think the three panels have done well, so you can only give us a round of applause and then we leave.
Thank you very much, our notable panel members, for leading this discussion. Before we call on the provost to give us the closing remarks, by way of information to our invited guests and all of us gathered here, I would like to make us aware that the faculty has provided or has made provision for certificates of participation, and anyone interested should see the gentleman seated at the front desk and leave the details with him. It would be ready in a week's time. And if you wish for it to be posted to you, kindly leave with him your postal address as well. So at this juncture, I would like to call on the provost of the College of Humanities and Social Sciences to give us the closing remarks. Let's put our hands together for him.
Thank you very much. It has been a long day, right? So I will not take my time, just 45 minutes. Nana, you seem shocked. Well, I was listening to it throughout the day. Some of us have to even get out, but we are still with you online because of the access to Zoom. And a whole lot of issues have been discussed. And so if I attempt to paraphrase it, perhaps I'll be doing a lot of injustice to some of the information that has been given us. And that is why I'm excited that we had reporters. And we are also encouraging all the panelists to give us their memos, documents that actually express their thoughts. Because we also have a research team that is at the end of the day going to sit down and put all our thoughts together. It is very necessary for the ministry to have such a document and work with. I like what the dean said. We are academics. We have been consulted. We are only providing what? Expert opinions. We believe it is incumbent on government to seriously take a look at them and work towards a standard. As we were saying, whatever it is for us is very useful, because at the end of the day, a standard will be what? Established, on the basis of which the lawyers will go to court if the government fails to, go along with our dictates. So on that note, on behalf of the Vice Chancellor, we want to thank all the participants and to wish you a very good evening. Thank you.
Thank you very much, Professor Marfo for that brief closing remarks. At this juncture, I would like to call on the Registrar of the Faculty of Law, Mrs. Abigail Zama Anderson, to give us the vote of thanks.
Our special guest of honor, Honorable Francis Asenso-Boakye, Minister of Works and Housing, Professor Mrs. Rita Akosua-Dickson, Vice Chancellor, Chief Director and Directors of Ministry of Works and Housing, my lords and members of the legal fraternity, members of the University Governing Council, Provost of College of Humanities and Social Sciences, Professor Charles Ofusumafo, Provost and Deans present, Nananum, Directors, Deans and HODs, staff and students, media fraternity, our most valuable guests, ladies and gentlemen. It's my privilege to offer thanks on this occasion. Such an august event cannot happen overnight. Wheels started rolling around a week ago. It required careful planning and attention to details. People have participated and willingly completed tasks beyond their comfort zone. We have been fortunate enough to be supported by a team of very motivated and dedicated colleagues from academia and industry who excel at their jobs. I would like to express our sincere thanks to the Vice Chancellor of the best university in Africa for quality education, Professor Mrs. Rita Akosua-Dickson, for accepting to chair this important event. I would like to express our gratitude to the Minister of Works and Housing, Honorable Francis Asenso-Boakye, for not only accepting to be our special guest of honor, but also providing funding from the ministry to support this colloquium. Honorable, we are deeply grateful. I should mention our appreciation for the deep dilation of the philosophy, policy, and constitutional context of the Rent Bill and Housing Bill, as well as discussions of their specific clauses that the 17 panelists under the expert moderation of Dr. Usudapa has done here today. It was thought-provoking and pleasurable listening to you all. Shall we give them a round of applause, please? We would also like to acknowledge our distinguished audience for your valuable contributions toward these two bills. I would like to take this opportunity to say thank you to our able and competent Dean, Dr. Enes Usudapa, for his capable leadership that brought forth this great event. Sincere thanks go to our research and planning teams, facilitators, staff, and the student body. Finally, our greatest thanks, you agree with me, goes to the Almighty God Jehovah, who made life and good health, as well as traveling mercies possible for us today. Madam Chairperson, ladies and gentlemen, thank you very much for spending the day with us.
Thank you very much, Auntie Abigail, for that wonderful vote of thanks. This is the moment most of us have been waiting for since lunchtime. And the moment is finally here. We would like to call upon Reverend Father Dr. Anthony Efner, the chaplain for the Catholic Church, to give us the closing prayer. Let's put our hands together for him as he comes up stage.
May I please beg your indulgence to please rise for prayers. Our help is in the name of the Lord who made heaven and earth. Dear Lord and Master, we are so much grateful to you for the gift of our lives. We thank you for this day. We thank you for this opportunity given us to interact with ministry and the academia. And we thank you for also giving us all the graces and blessings that we need to think and to plan towards offering decent housing for ourselves as a nation. We thank you for the Ministry of Works and Housing. We thank you for what you use them to do for us as a nation. We thank you for our dear university, and we thank you for what it is for us. We thank you for our college, and especially for our law faculty, and all that you continue to use them in uplifting the image of our dear and noble university. We thank you for how far you have brought us. We entrust ourselves, our families, our dear ones, the work of our hands into your care. May we continue to enjoy your favors, your blessings, and your protection in our lives. Even as we depart from here, we pray for traveling and journey mercies to our destination safely and sound. And that even you dispel the darkness of this night, renew us in our energies and strength, that at the dawn of a new day, we may rise up with more energy, with more strength to go about our activities, thinking for the development of our dear nation. May your favors and blessings be upon us, the Father, the Son, and of the Holy Spirit. Amen.
Thank you very much. The program has come to an end, but we would call on all the dignitaries to come upstage for a photograph. All the panel members, our invited guests, the Deputy Minister for Works and Housing, and the Director of Works, and Nananom, kindly come upstage. Yes, please. Representative from the Attorney General's Department, please, you are invited to come up stage.